Morning, everyone. Welcome back.
Good morning.
So we had talked earlier about the fact that we'd be going into closing arguments today, and that's what we'll do. Sorry, Ms. Hall, I had to cool the room down. Ladies and gentlemen, before we start, I just want to say that I was recently had a blood draw in connection with a doctor's appointment, and the technician was a person who came to the United States 14 years ago from Eastern Europe, and is now a citizen, and has been called to jury service 3 times. Twice in Navy court, once in common pleas court. And she was very proud of the fact that she had served and had participated in our system. And I hope that you will have that same feeling when you're done, because we certainly have enjoyed having you here. But as you know, you're here to help us resolve a dispute. But I think it is a great system, and we're trusting that you will complete your duty and that you'll encourage your friends and family to participate if they have a chance. Okay. So when we were here initially, we had the opening statements of counsel. Now we have the closing arguments. The attorneys are going to try and draw together the evidence as they heard it, and then present an argument to you as to why a person should be found guilty or not guilty, why the state has met its burden or has not met its burden. Okay? When we did the initial opening statements, each side went and spoke to you. But you understand, the burden of proof is with the state, so it's slightly different for the closing arguments. The state goes first. I believe Ms. Jordan will be doing that portion. Then the defense has a chance to argue, and then the state has a chance to argue a last time, and a rebuttal argument, so to speak, because they have the burden of proof so that they get the last word. All right. Now, I do want to caution you throughout this. If you feel that I have given any indication of how you should decide this matter or proceed in this matter, I don't. Right? So disregard anything if you think I have any personal feelings about what your outcome should be. My job is to provide a forum for the attorneys to come in, present their evidence. I will give you the law, and then you will be the deciders in this case. All right? So your decision is what's necessary and proper here. All right? So we have to say, and ladies and gentlemen, as I said earlier, you'll have a copy of this written charge with you. All right? The attorneys have been working with me hard on it to prepare it for you, so they have a copy as well. So they know what law I will be giving. So they may reference it or not, but they understand very well what law that they're going to ask you to apply to the facts as they heard them. Thanks.
Driving in the berm of a highway, that's not an accident. That's a conscious decision. Following too closely behind a car, that's not an accident. That's a conscious decision. Taking your dose of methadone at 12:34 p.m. at East 55th and Euclid Avenue in Cleveland, Ohio, and making it to I-90 westbound at the Cleveland-Lakewood border to strike and kill Trooper Kenneth Velez at 12:44 p.m. 10 minutes later. Throughout this trial, you've heard testimony and evidence about decisions that this defendant made on September 15th of 2016. Not accidents, not missteps, but conscious decisions every step of the way. That's what this case is about. This case is about the choices he made. The fact that the defendant disregarded everything else and did whatever he wanted to do. Alabama said your license is suspended. This defendant came up to Ohio, tried to get a license here. Somebody was driving too slow on the highway. This defendant got right up on their tail. And when that person started to slow down, this defendant didn't. What did he do? He drove inside the berm of a highway. That's not an accident, that's a decision you make. See, when most of us drive off in the berm of the highway, it's to change a flat tire because there's an issue with our car, or something is going on that would justify that. It's not because we're speeding down the highway. It's not because somebody else sees law enforcement and properly stops. But that's what this defendant did. Instead of making sure he had enough distance on that road to stop and do the right thing, he said, forget it. I'm just going to drive in the berm. I'm not going to slow down, not going to stop, not going to follow any laws that apply to the roadway. I'm going to drive in that berm. And when he made the conscious decision to drive in that berm after taking his methadone 10 minutes before, he killed someone who was on the berm doing their job. That's not an accident. That's a decision to do whatever you want to do on that day. That's a decision to disregard, to show reckless and heedless indifference to what our laws are. That is the action this defendant undertook. And so let's walk through the counts and talk about the evidence you have to support each and every count. Well, when we look at count 1, let's be honest. Nobody's disputing that the defendant was driving that day. You heard multiple witnesses come in and testify. Yeah, we all saw the defendant driving that day. That's not in dispute. No one's disputing the fact that this defendant striking Trooper Velez was the cause of his death. That's not in dispute. And so what really is in dispute in this case? Well, there's an argument that they're trying to say, well, maybe the defendant wasn't actually impaired. And so you have to go back and look at the evidence. What do you have to show you that, in fact, the defendant was impaired? And as the judge said, he's going to give you the law, but we're going to talk about it a bit. No person shall operate any vehicle at the time of operation. The person is under the influence of alcohol, a drug of abuse, or a combination thereof. Methadone is a drug of abuse. The judge will tell you that in your jury instructions. So there's no question that the defendant was driving his car. There's no question that the defendant had taken a drug of abuse 10 minutes before he struck and killed Trooper Velez. Recall the testimony that you received. 12:34, you see the video of this defendant taking his methadone. 12:34 p.m. By 12:44 p.m., he struck Trooper Velez on 90 westbound. And what else do you have to show that this defendant was impaired? Well, you have the observation of professionals on the scene who just stopped to help. Remember, at the beginning of this trial, we had those innocent bystanders who came in and spoke with you. And they spoke with you about why they stopped and what their observations were. And what their observations of the defendant were. And why, even as normal people responding to the scene, they had concerns that this defendant was impaired. And then you have Sergeant Gable's testimony. And he went through extensively his training and experience, his 16 years on the force, all his certifications, the fact that he is an instructor in these courses now. And he walked you through step by step what made him think this defendant was impaired. So let's talk about, first, what those lay witnesses saw. The people who were driving on the same highway as the defendant, but they didn't drive in the berm and kill anybody. It starts off with Trooper K, who saw the crash on the road, stopped to assist, and said his observations of the defendant was he was emotionless. And there were no visible signs of distress from the defendant as Trooper K sat there and observed him. You have Jonathan Arroyo, who testified, and he says he saw the officer as he was going over the hill, and that the defendant was talking, but he wasn't making any sense when he was talking. You know, just the fact that he said he looked down for 1 second, and then when he looked up, the officer was just there. That kind of just didn't sit right with me. Mr. Arroyo said the defendant was slurring his words. This was somebody else who was on that highway, driving, but didn't make the conscious decision to drive in the berm like the defendant did. And then you had Dr. Keegan Conroy, who talked extensively about his observations of the defendant. He talked about the defendant not doing what everyone else did. And in fact, we took down a couple of his quotes because they were so significant. He was asked about whether or not he didn't note the actions of the other vehicles by defense counsel. And his response was, I think I did not mark their actions because their actions were consistent with everyone else, whereas the Gloucester's actions were considerably different. Everyone else on the road that day obeyed the laws. Everyone else slowed down. Everyone else did not drive in the berm and kill someone, but the defendant did. The doctor went on to say he didn't slow to meet the pace of traffic. He rather kind of came up on the car in front of him quickly, then swerved into the left lane rather than just slowing and staying. That's a conscious decision. When you decide that I'm not going to slow down, I'm just going to go around this car by driving in the berm, that's not an accident. That's a decision that you make. The doctor went on to be asked, well, what adjective would you use to describe the Gloucester's reactions to slowing traffic? And he said, I thought it was inappropriate. He was driving inappropriately fast relative to the other traffic. So who else other observations do we have? Well, we have the Homeland Security Officer, Officer Dario, who again described the defendant as having an apathetic demeanor. And then you have Anthony McGraw, who came in here and was the EMT who was also driving on that highway, responding to that scene. He walked you through carefully every step he took to try to assist Trooper Kenneth Velez. And then after he assisted Trooper Velez, he told you that he remained on scene. And he told you as well about some of his observations of the defendant. And he said, the defendant was out of sorts, distracted while speaking, anxious and a bit confused. He said he seemed unnatural, like he was under the influence of something. And Anthony McGraw was so concerned about that he told you, I made sure I stayed on scene and told law enforcement that I had concerns about whether or not this defendant was under the influence. He made that point very clear. He didn't do the standardized field sobriety test, but he did say he was heavily trained in drug impairment. That's part of his job as an EMT. He walked you through that. He has to deal with overdose people and things of that nature. He says, I have training in this field. And based on my observations, I had concerns that this defendant was impaired. And then you have Mr. Sanford, who again said, he slowed down. He didn't hit anybody. He didn't drive illegally in the berm. When he safely could, he got over. And so what else do you have? Well, we have Mr. Wachowski, who said people were slowing and then he heard the sounds of the crash. We had Gene Fitch, who again observed the defendant. And why do we keep going back to the fact that the defendant didn't have any injuries? Well, there were some injuries to his hand, but there kept becoming these questions. Well, maybe he hit his head, maybe he did that. That's not evidence. That wasn't the testimony that was in front of you. The testimony that was in front of you was that the only visible injury observed to this defendant was something to his hand. That's it. And so you can't conjecture and speculate on something that's not evidence. And the evidence is the only injury to this defendant was his hand. And then you had Jenny Peacher come in and testify. 40 years of experience as a nurse. She told you her observations from the scene. And she told you that she was so concerned about the defendant. She observed the constricted pupil. She had such concerns about his impairment that she flat out asked him, are you on something? Not only did she relay her concerns to law enforcement, but she asked the defendant. That's how certain she was, based on her training experience, that there was some sort of impairment going on with the defendant. And she said, what are you on? You look like you're on something. Are you taking drugs? That was what she asked this defendant. And then we have Sergeant Gable's testimony. And he walked you through, step by step, the totality of the circumstances that he observed in drawing his conclusions. And he talked to you about the constricted pupils that he noted on the defendant. He explained to you that the defendant spoke in a low, raspy voice. He said the defendant seemed confused. He had to repeat his instructions over and over and over again. The defendant still asked questions about the instructions he had just been given. He talked to you about the fact that the defendant volunteered that he was in a methadone program. So at this point, we knew the defendant was on a drug abuse because the defendant disclosed that to the officer. He talked about the presence of a lack of convergence and the obvious leg and body tremors on the defendant. And then he walked us through each and every test he gave this defendant, trying to confirm or negate all the suspicions of impairment. And before he even got to the test, I think it's important to note that Sergeant Gable said, hey, I need to observe this guy before I even ran him through tests. I wasn't trying to jump to any conclusions. I wanted to do a thorough investigation, so I observed him. And at the point that I observed all these warning signs, it was then that I said, yes, we're going to administer the standardized field sobriety test. And so we did. On the walk and turn, the defendant had obvious leg and body tremors. He stepped off the line during step 4. He failed to touch heel to toe on step 7 and 8. After step 9, Sergeant Gable went through extensively. I didn't necessarily count that as a cue because he didn't quite put his foot down as he was taking that 10th step. But he did begin to take that 10th step. And then he talked to you about the turn that the defendant did. The sergeant stepped off the stand and demonstrated to you, these are the instructions I give before I administer this test. I tell the individual, keep one foot planted and turn, taking a series of small steps. And then you saw in the video that he gave the exact same instructions he told you he had. And you also saw in the video that the defendant did not follow those instructions. He did not turn with a series of small steps, rather he took one large step and then another small step. Then the defendant failed to touch heel to toe on return step number 7, and again his arms were rigid and his fists were clipped. So then let's talk about the one leg stand test. Well, the defendant swayed significantly throughout the test, and his arms were very rigid at his side. Sergeant Gable talked about the modified Romberg balance test as well, and his observations of the defendant there. Again, body very stiff and rigid, fists tightly clenched. And the sergeant was honest. He said, when I asked the defendant to estimate 30 seconds, he counted right around 33, 34. Every step of the way, the sergeant was truthful in reporting his observations to you. And then he talked about seeing the defendant's carotid pulse during that test and seeing it beat very rapidly. And then the finger to nose test was the last test he administered to this defendant. And you saw it clearly on the video, and Sergeant Gable walked you through each and every observation he had of the defendant while he was taking that test. On the first attempt, he raised his right hand instead of his left, used the pad of his finger to touch his nose, held the touch for 3 seconds. That wasn't consistent with the instructions. If you recall, Sergeant Gable walked through very carefully how the defendant should have raised his finger, which part of his finger should touch which part of his nose, and he said he did that for a very specific reason, because it was in walking through those tests he is able to determine whether or not that impairment is present. It is those details that matter. It's those details that feed into the totality of the circumstances. And so in the second time, he again tells the defendant which hand and finger to raise. He's instructed to raise his left hand. He's instructed to raise his right hand and raises his left instead. He double tapped his nose, held his finger on his nose instead of immediately place it down. On his third, he raised his right hand instead of his left. He touched the bridge of his nose instead of the tip of his nose. And yet there were still more ones. Number 4, he correctly brings his hand up and touches his nose. Number 5, he correctly brings the right finger up But again, he touches the bridge of his nose. And Sergeant Gable even demonstrated to you. After he touched the bridge of his nose, he dragged it down to the tip. Yet another indicator. 6. He correctly touched the left hand to the face, but he brought it up and kind of hovered it over his face instead of immediately bringing it down. And why is this test so significant? You know, you had another person come in and testify to you as an expert, and that was Mr. Palacios. He pretty much wanted to ignore this entire test. And Mr. Palacios, when he came in and testified, he went back and forth, said, I just went off Sergeant Gable's report, I watched the video, and this is how I drew my conclusion. Discounted all the eyewitnesses from the scene and their observations, discounted everything Sergeant Gable said, and then admitted to you, 100% of the time, in my experience being a paid expert, I testify for defense. 100% of the time, I testify for defense. That's what he told you. And so as he sat there and picked apart, playing Monday morning quarterback, the work that Sergeant Gable did, he wanted to completely ignore this test. And then he says, well, yes, you have to analyze impairment under totality of the circumstances, but you're misunderstanding what I mean by totality of the circumstances. No, sir, we don't. We understand what totality of the circumstances mean. We understand that that means you consider everything. That is, by definition, totality of the circumstances. And so, after you decide the issue of impairment, you have what's called a furthermore specification. And that talks about whether or not the defendant had a valid license at the time. And I highlight this section because it's important to note the ORs, which is why they're highlighted in yellow. It's not required that we prove everything in the statute. What is required is that we prove an aspect of the statute. And what's significant here is, or was operating a motor vehicle or motorcycle, did not have a valid driver's license. That's what this specification hinges on. And whether or not the defendant had a valid driver's license is a question of fact for you. We don't get to tell you whether or not he had a valid driver's license. That's for you to decide. And so what information do you have to decide whether or not the defendant had a valid driver's license? Well, we know the defendant's Alabama license was suspended. We know that for a fact. We know it still is suspended to this day. We know that on January 26, 2016, the defendant obtained a state ID from Alabama. And Dina Pregno came in here and she testified to you that Alabama does not issue both a driver's license and a state ID. So as of January 26, 2016, this defendant knew he didn't have a valid license in Alabama because he got that state ID. That's not in question. February 10th, 2016, defendant comes to our state and decides, well, I'm not going to tell Ohio my Alabama license is suspended. I'm just going to apply for a license here. February 10th, he applies for a temporary permit. February 11th, he applies for a driver's license. And you will have States Exhibit 1472 and 1473 with you. And what does it say? Before this defendant signed, I do not have driving privileges now suspended or revoked or canceled or otherwise disqualified or subject to an out-of-service order in this state or any other state. That's what he told Ohio, not once but twice. He lied. His Alabama license was suspended and he did not disclose that. He made the conscious decision that law wasn't going to apply to him and he could just do what he wanted. And then you have the additional specification on a peace officer. And the question then comes to you was, at the time that this defendant killed Kenneth Velez, was he a peace officer for the state of Ohio? And you do have that evidence, and in fact you have a stipulation that at the time our victim was killed by this defendant, he was a highway patrol officer in full uniform on the highway doing enforcement. One of the things the judge is going to instruct you on is something about other causes. At some points throughout this trial, defense counsel made some allusions to the fact that, well, maybe the trooper was in the wrong for how he was doing enforcement. Well, maybe there was a car in front of the defendant that slammed on their brakes. And that's the point in time when it's important to listen to the judge's instructions. While, of course, we as the state of Ohio dispute all of that, the judge will instruct you. There may be one or more causes of an event. However, if the defendant's act or failure to act was one cause, then the existence of other causes is not a defense. That's smoke and mirrors. His assertions that maybe Trooper Velez did something wrong or maybe the blue car slammed on the brakes, that has nothing to do with the defendant's actions according to the law. That cannot be considered. It's not a defense. And so then we go into count 2, which is another aggravated vehicular homicide. Again, not a question the defendant was driving. Again, we know the cause of death was the defendant's action. And so what does this turn on? Well, it turns on the idea of recklessly. And that's when recklessly is defined for you again by the judge. A person acts recklessly when with heedless indifference to the consequences, the person disregards a substantial and justifiable risk that the person's conduct is likely to cause a certain result or is likely to be of a certain nature. The person is reckless with respect to circumstances when with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk that such circumstances are likely to exist. To constitute recklessness, one must act with full knowledge of existing circumstances. Speed alone is not sufficient enough to constitute recklessness. And so what do we have? Goes back to one of the first decisions the defendant made that day. And here, from the trooper's own dash cam, we see this Honda Civic, and then you see the defendant's car immediately behind that Civic, not keeping his assured clear distance, not giving himself enough space, making a decision that he was going to speed, that he was going to be right there, riding that person's tail in the fastest lane on the highway. And then you have the image where you see again the defendant's car continuing to move up on the trooper. And then you see this defendant again make the decision, regardless of whatever else is going on, not caring about anything else, only that he wanted to continue along his path of travel. He made the decision to drive into the berm. That's not a legal lane for driving. He made a decision, instead of slowing down, instead of stopping, instead of just not being so close to the car in front of him, he was going to drive inside the berm of that highway. And that's what he did. And so why do we have these brake marks up? Because it's important. It's important to note that the first time we see any indication of this defendant making any attempt to brake, his car is already in the berm. We don't have any evidence of this defendant attempting to brake on the highway in the actual lane of travel, the left lane of travel. The first point in time where we see evidence that he tried to slow down, that he tried to confine himself to some sort of norm, he's already in the berm of the highway, traveling in excess of the speed limit. The first time we see any indication of him trying to comply. And so as we talk and think about recklessly, my attention draws back to the words that the doctor expressed about his observation of the defendant's driving. Because he was the one that was on the highway with it. He was one of those other drivers that did not drive in the burn, that saw the officer, that safely stopped, that did everything we would expect them to do, that made the conscious decision to do the right thing, as opposed to try to devise their own way of travel. And again, the doctor said, the black Hyundai Veloster approaching the slower traffic relatively quickly. Even the doctor was able to note that other traffic was slowing down. But this defendant decided he wasn't going to do that. As the rest of traffic slowed, the defendant continued to approach rather quickly. Saw the car swerve into the left lane, I assumed attempting to pass slower moving traffic. Saw the car swerve into the left lane, I assume attempting to pass slower traffic. Everyone else on that highway saw the truth. Everyone else slowed down. Not the defendant. He still wanted to travel. He still made the decision to proceed at the rate of speed he wanted to go at. No care, no focus on anything else, just on what his efforts were. And then he was asked, you used the word swerve. And his response was, I chose that word because the motion was a bit uncontrolled. He moved rather quickly, went off a bit into the left median, then made a couple additional motions to the right and left, so it seemed somewhat uncontrolled. As I said, that's why I chose the word. It's very descriptive in his observations to you of what the defendant did. At no point in those observations was there any notation of the defendant slowing down, still traveling at whatever rate of speed he wanted to. What adjective would you use to describe the Veloster's reaction to slowing traffic in front? The doctor's response, I thought it was inappropriate. And again, we come back to the additional furthermore specification on count 2 as well. Will you as a jury get to decide whether or not in fact the defendant's license was valid? And so again, we go back to the Alabama ID that he obtained on January 26th and his actions here in Ohio on February 10th and February 11th. And again, don't forget the defendant had to sign that paperwork not once, but twice, stating that he did not have a license suspended in another state. He chose just not to disclose that. And so how do we make the determination, or what facts do you have, or what evidence do you have to support the fact that that license wasn't valid? Well, you had testimony from DMV reps, both here in Ohio and from Alabama. And they explained to you the process of what would happen. Don Sweatpig from the Ohio DMV testified the defendant was given 2 opportunities to disclose. 2 opportunities to disclose that his license was suspended in Alabama. She testified that he would have never been issued an Ohio license if he had to disclose that he was suspended in Alabama. We asked her that question numerous times. Well, what would have happened if? And she flat out said, at the point that you disclose that you are suspended, the process stops. A license is not issued. That's it. If the defendant hadn't been truthful and honest, he wouldn't have had in possession that license. So the question remains to you is, if you lied to get a license, is it valid? That's the question for you to determine. That's a question of fact for you. We won't make it one. And she also testified that it's not the computer's responsibility. The computer is a check. It's the defendant's responsibility to disclose whether or not he was suspended. And he chose not to. Again, this is about conscious decisions this defendant has made every single step of the way. And then you have Amberlynn Daniels, who came in also from the Ohio Bureau of Motor Vehicles, and she testified to you at length about the Interstate Compact Agreement. And why is that significant? Because as both Dawn, as both Amberlynn and Dina Pregno testified to, if the defendant is suspended in one state that's under that interstate compact agreement, another state will not honor him attempting to get a license. That's significant, because it goes back to the fact that supports what Dawn said. If he had to disclose the Alabama suspension, we would have never gave him an Ohio license. And then you had Christine Baker, who came in, who talked to you about when the defendant first became aware of his Alabama suspension. And she testified to you about the process that they go through in the court to be notified of it, the fact that when he came to her for their first meeting, she informed him of it, and she said the defendant knew his license was suspended. And then you also had Dina Pregno from Alabama. She testified to you that there's a process in Alabama to get your license reinstated once it's suspended. The defendant did not undertake that process. She testified to you that the defendant obtained the Alabama ID card January 26, 2016, which is about 3 weeks before February 10th and February 11th of 2016. That goes to the defendant's level of knowledge. That goes to his level of deception. And within 3 weeks of obtaining the state ID card from Alabama, he's in Ohio saying, I'm not suspended. I'll take a license in this state. Again, conscious decisions made by this defendant. And she testified that if you are trying to transfer your license from one state to another, it has to be valid in the state that you're transferring it from. She testified the defendant's license is not valid in Alabama. It is suspended. And again, on count 2, we have to prove to you that the victim in this case was in fact a peace officer at the time the defendant killed him. Now there is a lesser included that is being offered on count 2. And it's important to note that you do not move on to even begin to consider the lesser included if you believe we met our burden on the main offense. And the state will submit to you that we believe we have. However, it's important for us to review that with you as well. Defendant did, while participating in the operation of 2015 Hyundai Molester, caused the death of Kenneth Velez, an Ohio Highway Patrol trooper, negligently. Again, this is only considered if you do not believe we have met our burden on the main count. And so then you determine whether or not, instead of reckless, the defendant was negligent. And the judge will provide you the definition of negligently. And again, you still have to move on to that furthermore specification regarding the defendant's license suspension and whether or not he had a valid license. And so then we move into count 5, which is the operating while under the influence. Again, I don't believe there's anything contradicting the fact that the defendant was driving that day. And so then when at the time of operation, he was under the influence of alcohol, a drug of abuse, or a combination of them. Again, methadone is a drug of abuse. We know at 12:34 he ingested his methadone. We know at 12:44 he struck and killed Trooper Velez. And so then we again turn back to the observation of the witnesses on the scene and the observation of Sergeant Gable. And again, we talked about the observations of the witness. From Trooper K to Jonathan Arroyo, who said the defendant was slurring his words, his behavior just did not sit right with me, to Andre Dario, who again described the defendant's demeanor as apathetic, to Anthony McGraw, who carefully noted his concerns, his observations, to the point that he said, I wanted to make sure law enforcement on the scene knew of my concerns, and he told them. To Gene Fitch again, no visible injuries to the defendant, and then Jenny Petrick again, flat out asking the defendant, are you on something? And then again, all of Sergeant Gable's observations, all of his testimony applies to count 5 as well. You will have those exhibits with you. You will be able to review the standardized field sobriety test video. You will have all of that in front of you. You will be able to know for yourself the defendant's performance on these tests. And don't forget to pay attention to the last test. Don't be like Mr. Palacio. Consider the totality of the circumstance. Consider all the observations of the defendant. Consider his performance on all the tests. It's not about piecemeal. It's about considering every fact that would have indicated whether he was impaired or not. And then remember, at the end of Sergeant Gable's testimony, he gave his opinion as an expert. He said, based on my years, my training, my experience, my certifications, the fact that I'm an instructor in this field, based on all the observations I had of the defendant, I thought he was impaired. That's the evidence you have before you. That's the testimony you have. And so then we turn to count 6, which talks about the motor vehicle offense. And the question is, did operate a motor vehicle upon a public roadway while his driver's a commercial license or permit operating the privilege? So again, not in dispute that the defendant was driving. Was suspended under any provision of the revised code other than the chapter 4509 of the Ohio Revised Code. And this is where the or becomes important again. Or under any applicable law in any other jurisdiction in which his license or permit was issued. Well, we have another jurisdiction where his license was suspended, and that's Alabama. And Dina Presley told you that his license is still suspended there. And that he failed to disclose that suspension to Ohio at the time he tried to obtain his Ohio license. Again, we have the testimony of all the B&B reps, the Ohio B&B reps, the Alabama B&B reps, and they all state if the defendant had disclosed his Alabama suspension, the Ohio license would not have been issued. And so then we turn to count 7, which is the tampering with records count. Did knowing he had no privilege to do so. Well, how do we know the defendant knew he didn't have a privilege to do so? Goes back to the fact that in January of 2016 he gets the Alabama state ID. So he knew he didn't have a privilege for Ohio license. And with purpose to defraud or knowing he was facilitating a fraud on the representative of the state of Ohio Bureau of Motor Vehicles. Well, what do we have to show that? Again, turns back to what he did in Alabama 3 weeks before. He got that state ID, and then he never tells Ohio that he's suspended in Alabama. Utter in writing, to wit, tamper with the application for a temporary Ohio driver's license. Defendant signed for a temporary permit in Ohio on February 10th of 2016. He signed for an Ohio license on February 11th of 2016. Both times indicating that he was not suspended in another state. Both times lying to a state official. Both times providing false information to the B&B. Those are conscious decisions made by him every step of the way. Knowing this to have been tampered with as provided in Division A1 of this section, and the writing, data, computer software record was kept or belonged to the local state. Well, the Ohio B&B came in and said, we keep these records in the ordinary course of business. Here are the documents. And you will have those documents with you during your deliberations. And so then we turn to count 8. Again, another tampering with records. Did knowing he had no privilege to do so. No question about knowing his license was suspended in Alabama, and is still suspended in Alabama because he got the state ID card. And with purpose to defraud or knowing he was facilitating a fraud. Well, how do we know the defendant knew he was facilitating a fraud? He did not disclose the suspension. He wasn't trying to hide anything from the B&B. If he wasn't trying to facilitate a fraud, he would have just said, yeah, my Alabama license is suspended. Here's my Alabama state ID that I got 3 weeks before I came to see you all. That's not what he did. He again signed the form and states exhibit 1472 and 1473 saying, I do not have driving privileges now suspended. That's a fraud. And again, we have testimony from the Ohio B&B witnesses and the Alabama B&B witnesses. So then we turn to count 9, which is certain acts prohibited. Did any application for identification card, driver or commercial's license, temporary permit or commercial driver's license, or any renewal or duplicate thereof, knowingly concealed a material fact. And so what's the material fact that this defendant concealed? I'm suspended in Alabama. That's the material fact we're talking about. I just got an Alabama state ID 3 weeks before I came to see you all. Signing the form, I do not have driving privileges now suspended. fixing his name signature to the bottom of that form. And again, testimony from our B&B witnesses. And so we move on to the falsification. Did knowingly make false statements. Well, goes back to the form. There's a false statement. I do not have a suspended license. We know that's false. You did have a suspended Alabama license. Or knowingly swear or affirm the truth of the false statement when the statement was made with the purpose to mislead a public official. Well, how did he mislead the public official? Again, that's the B&B. That's when they ask you, is your license suspended? And he says no. And performing the official's public function. Well, their function is to administer licenses. And he decided that he wasn't going to be truthful and honest. We had Sergeant Thorne come in and talk to you about what Ken's day was like on September 15th of 2016. We had him come in and talk to you about what Ken did leading up to the defendant striking and killing him. It's important because it shows you, again, that Ken was performing his official functions as an Ohio State Highway Patrol trooper. He entered the academy in 1989. He spent 28 years serving the Ohio State Highway Patrol. He was recognized for his safe driving, and he was assigned to the Cleveland Post in January 2016. September 15th of 2016, the day he was struck and killed by the defendant. That morning, he was doing his morning paperwork. He completed his follow-ups. He wrote some tickets later on that morning by milepost 168. He ate lunch with another trooper. He went to Parma Juvenile Court to file some charges there. At 12:35, he runs a registration check. 12:35 is about a minute after the defendant has taken his methadone. At 12:44 p.m., his camera is activated when he's struck by the defendant's car. And so we turn back to recklessly. Was the defendant reckless in his actions? And so we turn to Trooper Jester's report and his conversation and testimony to you. And what did he say? Well, part of what he said was the crash report has something called contributing factors. And they walked through what contributed to this crash occurring. And what Trooper Jester testified to you is that the defendant was following too closely to the vehicle in front of him. And the defendant made an improper lane change and was passing off the road. That's what caused this action. That's what caused this crash. It was the defendant following the car in front of him too closely, and the defendant choosing to drive in the bar. And it should also be noted in the crash report that when it looks at the contributing factors of the non-motorist, which would be Trooper Velez, there are none. Trooper Velez died as a result of this defendant's choices. And so then we talk again, just so we're clear about where Trooper Velez was situated in relation to this burn. 8.75 feet his car was at the front, 8.34 feet away from the lane of traffic. And so we talk a little bit about, again, well, let's consider everything. Let's check the defendant's car to make sure there were no issues. Let's check to make sure that his brakes were working. Well, they checked the braking system. No issues. The brakes on the defendant's car are not a suspected factor. And so we go back to the defendant just didn't want to ease up. He didn't want to slow down. He didn't want to keep a clear distance. He wanted to do whatever he wanted to do. And so the speed calculations become important because at the first moment that we can know what the defendant's speed is, it's when we see these brake marks. And Trooper Jester told you that I can't tell you what his speed was before I start to see those skid marks in the road. I can tell you he was traveling faster than the speed he was at the skid marks, but I can't tell you what that speed was. And so we know, based on that testimony and the calculations that the trooper conducted, that the point in time the defendant is driving illegally in the berm to get around another car, he's going 60 to 64 miles per hour. That's above the posted speed limit. That's the evidence we have. And so again, at the point in time where this defendant has entered the berm, mere feet away from Trooper Velez, not a lane of travel, the point in time he made the decision to not slow down, to not attempt to brake, to not just stop his actions, 62 to 64 miles per hour. Well, there was a question, which really is a question. The blue car in front of me slammed on his brakes. That's what defense counsel kept trying to get witnesses to talk about. We know from the diagram, the blue car is still in front of him. As this defendant is fully in the berm, again, Trooper Velez is in the berm. He's not in the lane of travel. As this defendant is going 62 to 64 miles per hour, the blue car is still in front of him. And you see it in the photo. As you see the legs of the trooper and you see the defendant's Hyundai Veloster, you still see the blue car in front of the defendant. And it takes us back to that speed calculation. And so we know at the point of impact, at the point that this defendant first strikes Trooper Velez, he's still traveling in the berm at a rate of 53 to 55 miles per hour at that first point of impact. We know at the first point of impact, where this defendant is fully driving that berm, Trooper Velez is still about 5 feet, 5 to 6 feet inside of the berm. So we know through the evidence that this trooper was not in the lane of travel. We know from the evidence that this defendant was in the berm of the highway. And we know the defendant continues to decelerate, and at the time that there's a second strike on the trooper, he's traveling at a rate of 32 to 34 miles per hour. So at the time, the Trooper Velez's body comes down and strikes the back of the defendant's vehicle. He slowed down, finally. And we know at that point in time, he's still on the berm of the highway. And what else is significant about this photo, as hard as it is to see, is also what you don't know. There's not another car behind either the blue Hyundai or the defendant's vehicle. So as questions were asked about, well, maybe the blue car didn't stop, maybe the blue car stopped too fast, there's nothing that prevented the defendant from just stopping in his lane of traffic. There's nothing that prevented the defendant from just slowing down in that lane. There's nothing that prevented the defendant from doing the right thing other than the choices he made. So instead of slowing down, instead of just stopping in the left lane, he continued at his rate of speed. He continued into that left berm, and that is when he struck and killed Trooper Velez. And so we go back to the observations of the defendant, the witnesses on scene. That's how you determine the recklessness of this defendant's actions. You gauge it against the other people who were there, the other people who said, we're going to obey the traffic laws. We're going to keep enough space between us. And you gauge it based on their observations of this defendant, because that's the information we have in front of us. They're the ones who saw him driving recklessly. They're the ones who noted that he was driving inappropriately fast relative to the other traffic. They're the ones who noted his signs of impairment in addition to the tests done by Sergeant Gable. Andre Dario, Anthony McGall, Michael Sanford, David Machowski, Jean Fitch, and Jenny Petrie. When we look at recklessly, those are the things we consider. At the time this defendant struck and killed Trooper Velez, at the time his brakes were finally activated enough to leave a skid mark, he was still traveling above the legal speed limit. And that was the point in time where he was fully into the berm, not the legal lane of traffic. At the time, the defendant failed to maintain an assured clear distance. You saw the video, you've seen the pictures again throughout this presentation. You will have them with you, all those exhibits with you during your deliberations. You will be able to make the determination of how close this defendant was to that car in front of him. The defendant was swerving in traffic as described by the doctor who witnessed the incident, and he was traveling still in excess of the legal speed limit while he was in that berm. And again, I just go back to the testimony of Dr. Conroy, in addition to the other witnesses, because he was probably the one that gave the most detailed observations of the defendant's manner in driving. What adjective would you use? Thought it was inappropriate. At the end of Trooper Juster's accident reconstruction report, he walks you through the causation associated with this crash. He walks you through it. And he says, physical evidence and witness accounts reveal that both Trooper Velez and a marked patrol vehicle were positioned in the southern berm, not encroaching on the nearest lane of travel. He says that the video evidence shows the defendant was traveling above the posted 16 mile per hour speed limit. During this, he also makes the conclusions that the physical evidence revealed that after the initial collision, the highway velocity slowed, allowing Trooper Velez to simultaneously strike the rear of the vehicle, and that Trooper Velez received incapacitating trauma. That's what this is about. We know we've asked you to be here for a significant time, and we thank you for your service. But we would ask that during your deliberations, you carefully weigh all the evidence that is before you, and that you think about the difference between conscious decisions made, the conscious decision to ingest your methadone at 12:34 p.m. at East 55th and Euclid Avenue, the conscious decision that within 10 minutes of doing that, we know that you're on I-90 westbound speeding, that within 10 minutes of leaving East 55th and Euclid, you are darn near at the Lakewood-Cleveland border on 90 westbound. Within 10 minutes. That you are driving at the time that we can finally indicate any sort of braking at 62 to 64 miles per hour. That there are lay witnesses who were so concerned about your impairment that they flat out asked you, are you on something? That another lay witness on the scene made sure, he testified to you, I wanted the law enforcement on scene to know that I thought he was impaired. I made sure to tell them of my concerns. And then Sergeant Gable taking you through very meticulously each and every observation that he had. These are conscious decisions made by the defendant. And then in spite of all of that, in spite of taking your methadone 10 minutes earlier, in spite of somehow making it all the way from East 55th to the Cleveland-Lakewood border on 90, East 55th and Euclid, making it all the way there in 10 minutes, in spite of just slowing down as the rest of traffic was doing, the fact that you decide to drive into the berm of a highway, not to fix a tire, not to check something going on in your car, but because the car in front of you is just driving too slow. Because instead of doing what everyone else is doing and obeying the traffic laws, you want to create your own set of rules. Those are accidents. Those are decisions. Those are mistakes. That's heedless indifference. That's not having any regard to anything else but what's important to you. That's what this defendant illustrated on September 15th of 2016. Those were the decisions that he made, and they were decisions. We ask that you carefully weigh and consider all the evidence presented to you. And we believe that once you do that, you will be able to return a fair and just verdict of guilty on every single count of the indictment that is presented to you. Thank you.
Ms. Jordan. Sam?
Trooper Velez's death was a tragic accident. And nothing the government has proved to you in the last 2.5 weeks has shown anything different. I understand there are a lot of people hurt by the trooper's death. And I understand that the government has to come up and put on a case. And I understand when this prosecution started, they wanted to let a jury make the decision. What I don't understand is trying to mislead you. What I don't understand is stretching the truth. What I don't understand is a mean-spirited prosecution that's just wrong. It's wrong. It's wrong to stand up here and tell you things that you know aren't true. It's wrong to stand up here and try and imply that Josh wanted to take the berm as a shortcut. That Josh just chose to ride on the berm as if it's something you choose to do. Maybe the cars in front of him were going a little too slow, so he was just going to pass on the berm. You know that's not true. We all know that's not true. Why don't they want you to know what the truth is? Why? Because the truth is, this is an accident. And if you drive on these roads and you are unfortunate enough to hit a police officer, you could be sitting in the same seat as Josh. And they could be coming after you the same way. Why don't they want you to know that there are 3 parties to this accident? There's the trooper, there's Josh, and there's Mr. Sanford in the blue Honda. Why do they shy away from that blue Honda? Their own accident reconstructionist has the blue Honda putting down a skid mark of 30 feet. Why? They know it. Why don't they bring it up? Because it doesn't go with their, oh, Josh is just crazy and careless and likes to pass on the berm. Let's look at what happened here. Let's look at what we know. We know Trooper Velez is a good man. We know he's getting ready to retire. We know he's a hero. He's out there. He's doing roadside enforcement, but he's standing outside of his car. And no matter what they say, and no matter what the Highway Patrol authorizes, that is dangerous. It's dangerous to stand outside your car on the highway. It's just dangerous. They've changed their policy now to put an orange vest on them. That didn't exist at the time. But I don't care what they put on them. People don't belong walking in that highway if it can be avoided. But Trooper Velez had a job to do, and he's out there, and he is using these pan methods to point people down. But let's get what he's really trying to do. There's nothing wrong with it, but he's trying to surprise folks and catch them speeding. He's not there as a warning. He's not there to tell you to slow down. He doesn't want you to see him. How's he going to catch you speeding otherwise? We know he doesn't want you to see him because people didn't see him. How do we know they didn't see him? Because they all hit their brake lights. We heard from witnesses that the whole crowd hit their brake lights. This is not a situation where you see a police officer 2 miles down the road and you just barrel right on through. Watch the video. Nobody was getting out of that left lane. That left lane was full of cars. This isn't liar in sights, pull to the right type situation. He was there with his gun catching you. And lights were lighting up as everybody went, there's a cop. But his signals, for whatever reason that day, weren't making sense. They weren't being understood. How do we know that? Because all the eyewitnesses thought they were getting pulled over. How many eyewitnesses came in here and said, I didn't know if he was talking to me. I didn't know if he was talking to me. I didn't know if he was talking to me. Confusion. Confusion is deadly when you're standing on the side of the road trying to direct 4,000-pound vehicles. It's deadly. And there was confusion. Mr. Sanford. Confusion. What Mr. Sanford did, I can't say it's not reasonable. How many of us have been driving along and all of a sudden had a police officer out in front of us giving him some type of signal? What's he saying? Is he saying to stop? Is it safe to go on? Am I in trouble? Are my wheels on fire? What's happening? Mr. Sanford didn't do what he was expected to do and go, I'm getting a ticket. I'll pull over. Mr. Sanford hit the brakes, locked him up. 30-foot skid mark. We see it. We can see him slam on the brakes right in front of Josh. 30-foot skid mark. That's the risk when there's confusion out there. That's the risk of this kind of enforcement. Maybe some of you experienced drivers say, you understood that, but put a young person out there, put someone who's nervous out there. It's dangerous. We all know folks who, if a cop jumped out at them in the road and did a hand signal, they wouldn't know what to do. It's dangerous. And Mr. Sanford didn't know what to do, and he slammed on the brakes in the lane of traffic. And that's when Trooper Velez, by all accounts, and I may be wrong on this, but my understanding is he started walking over to Mr. Sanford probably to go, no, burn, move it, because he's 5 feet. He's 5 feet from traffic, and 5 feet can sound like a lot, but 5 feet is from here to there. He's close to traffic. He's walking up, and he's from where I am to this table, and he's saying, I imagine, move over. But it's busy out there. Watch that road. Watch that video. Cars are flying by. No, they're not getting out of the left lane because no one knows that he's there. No one sees the trooper advance. They're not looking way out there and seeing him. He's surprising them. Put yourself in Josh's shoes. You're driving, going to work. You're on 90. Nothing crazy's going on. Maybe you're smoking a cigarette. Maybe you're listening to radio. Maybe you're thinking about the job you're getting ready to go bid on. You're keeping up with traffic. You're not going too fast. You're not going too slow. You're doing what we all do on 90. Next thing you know, the car in front of you slams on its brakes. Slams on its brakes. 30 foot. 30 foot decelerated. 30-foot skid mark. We can look at the video and we can see that the blue Honda landed parallel with the trooper's car. And we can see that Josh shot right around it. What do you do in that situation? You're on 90. It's a busy day. Guy slams on his brakes. By all accounts, these brakes take 190 feet to take you from the point where you're going the speed limit to the point that you're stopped. 190 feet. For the prosecution to suggest you should just hit the magic brake and stop the car, it doesn't work that way. It doesn't work that way. If you don't catch those brake lights the minute they shine in your light, if you're a second delayed, you're going to smash right into the car in front of you. So those are Josh's choices. Do I smash this car in front of me, which I'm about to do? We've all been there. We've all been there. When you're in traffic and all of a sudden someone stops in front of you, maybe not to the degree this happened, maybe not at this speed, but we've been there. And you look in your rearview mirror and hope no one's going to hit you from behind, or you start doing those mental calculations that you don't even know you're doing to try and figure out how to save this accident from happening. And as a reflex, I know there's traffic to the right of me. I know that. I know I'm going to hit this car in front of me. Emergency lane. What do? You head for the berm. you head for the emergency lane. That makes sense. That's your only chance. Your only chance is to hit that berm and try and slow down in the emergency lane and not make contact with anybody. And 99 times out of 100, 999 times out of 1,000, out of a million, that's the right move.
Objection.
Sustained.
Who would think that on that particular day there would be someone standing in that berm? Who would think that? Who would think that that highway patrolman would be there on that particular day when your mind makes that split-second decision to try and avoid an accident? Next thing you know, you're on the berm, you're locked up, and you're skidding. And you go 190 feet and 55 feet into the skid, you hit the trooper. You manage to avoid the car in front of you. You manage to get your car between a 10-foot space between the two cars, the trooper's car and the Honda. You hit that in that 3.9 seconds it took from start to finish of this whole event. You make the right moves. But 50 seconds in, there's a trooper standing right by his car. Trooper wearing all gray. Trooper you didn't see. And now you've hit him. And now you stop. And now you're in shock. And now you get out of your car. And there's nothing you can do, and you're wondering what's going to happen next and what's the right move, and you look at the trooper and it's clear that he's in bad shape, and people are jumping out of their cars, and you stay there, and you don't know what to do. Maybe you call your mom.
Sustained.
Josh stayed there, doesn't know what to do.
Objection. I would ask the court caution counsel.
You're not testifying. The jury will remember the testimony. It's the evidence, not what our opinion of the evidence.
We know that Josh got out of his car. We know that Josh stayed at the scene. We know that Josh watched as aid was rendered to the trooper. We saw the big pool of blood. We saw that. Josh was right there for it. Then people start coming up to him. People start saying things to him. Some lady comes up and accuses him of being on something when he's not.
Objection.
Still, Josh stays. No one's being nice. There's no testimony that anyone's coming up and saying, don't worry, it's okay. It'll work out. He's out there alone. Next thing you know, a man wearing the same uniform as the man he just hit asked him to start doing some tests. Want to think about Josh's state of mind? Josh was high, or Josh was drunk. What do you think his response would have been when the troopers tried to take him behind somewhere away from the cameras? The trooper said, hey, let's take you away from all these cameras that are set up here. Let's go somewhere where you won't be on the nightly news. Josh said, no. I want to be in front of as many cameras as I can be. Who does that? Who wants proof? Somebody who's not impaired. Somebody who's not drunk. Josh wanted proof. Think about his state of mind. Next thing you know, these officers have given you some tests, and you do fine, and you do fine, and finally you tell them your knees are shaking, you tell them you're scared. Finally, they give you a test, and the very last test after you pass them all, when you're so scared, they ask you to put your left hand on your nose and your right hand on your nose, and you get them wrong. You put your right hand for your left and your left hand for your right, and it takes about 30 seconds before you go, oh, I'm sorry. That's enough. That's it. You're locked up. You're arrested. And for the next 11 months, people call you a cop killer. And people say you were high on drugs, and that you were drunk, that you were speeding. And it takes 11 months before you finally get someone to come in and say, listen to the evidence. That's not what happened. This was an accident. This was an accident. The state of Ohio has thrown every charge they possibly could at Josh in an effort to try and get something to stick. And at the beginning I understood that, but now it's just mean-spirited to stand up here and mislead you and tell you that Josh somehow just makes crazy choices. That's not what the evidence was. Yeah, you could look at some of the eyewitnesses. Some of the eyewitnesses said this, some of the eyewitnesses said that. We're going to talk about them in a minute, but most of those eyewitnesses didn't even have their positions right. The eyewitnesses are relying on, once they saw the tape, said, oh yeah, I wasn't, that's completely different than the way I remember it. What you need to look at is the physical evidence. Look at the accident report. Look at the accident reconstruction. That's what's going to make the difference in this case, and that's what they don't want you to look at, the fact that the blue Honda stopped right in front of Josh. The charges. I'm going to talk a little bit about the charges in this case. As I said, in an effort to get something to stick, we've got a mountain of charges. Some you don't even understand. But as I take you through them, I'm going to ask you to follow me on them. First thing the judge is going to do is he's going to give you some instructions. One of the first instructions he's going to talk about is how you determine credibility of the witnesses. In determining credibility of the witnesses, you should consider the interest or bias the witness has in the outcome of the verdict. The interest or bias. I have nothing against police officers, and I have nothing against the Highway Patrol. And I understand they suffered a huge loss. But if this were you out there, or your son, or your husband, or your wife, would you be comfortable that the Highway Patrol would do an objective investigation when one of their own was killed? Would you be comfortable that officers who made the decision to gather the evidence, the decision to decide what's important and what's not important, can't even get to their testimony without crying about the loss of their friend? The trooper's friends investigated this case. His friends made the decision to bring these charges. His friends. Wouldn't it have been smarter to have the City of Cleveland investigative team do it? They were there. Wouldn't be something you could rely on? Maybe Lakemore didn't have jurisdiction. I don't know, but I'm not Lakemore. But maybe City of Cleveland could have done it. They were there. They had the ability. They had the tools. But the trooper said, "No, we'll take it." And the troopers didn't even get another division to do it. They didn't get another troop from Youngstown or from Columbus. Trooper Velez's friends did the investigation. So when you ask yourself whether a witness has a motive or a bias, subconsciously, unconsciously, you think these troopers want someone to pay for this? Do you think these troopers want to hold somebody responsible? Don't you think they want to be able to tell Ken's family that somebody's been held responsible for this? Because if it's just an accident, there's no one to blame. But sometimes it's just an accident. The first charge is this aggravated vehicular homicide, and that's premised on a DUI. Basically it says Josh is charged with killing Trooper Velez by reason of operating a motor vehicle under the influence. Don't be confused by under the influence, folks. It doesn't mean that you took a drug and all of a sudden you're under its influence. We all take prescriptions. We all have them working in our body. But under the influence legally has a very specific meaning. I'm going to read it to you. And then you have to ask yourself, based on what you saw, based on the observations you made, is Josh under the influence of this methadone? Now I get that later on in the game, the state changed its tune and started talking about caffeine and other drugs that don't show up on blood tests, but that's a stretch. That's desperation. When they started off, it was all about methadone, and methadone's the only thing in Josh's system. So the question is, does that methadone impair him? Under the influence means, the judge is going to tell you this, the defendant consumed a drug of abuse, and ladies, any prescription can be a drug of abuse, ladies and gentlemen, any of them. We all take drugs of abuse. The question is whether or not we abuse them. Methadone is a drug of abuse. The judge is going to tell you that. Under the influence means the defendant consumed a drug of abuse, whether mild or potent, in such a quantity, whether small or great, that it adversely affected and noticeably impaired the defendant's actions, reaction, or mental processes under the circumstances then existing and deprive the defendant of that clearness of intellect and control of himself which he would have otherwise had possessed. The question is not how much of a drug of abuse would affect an ordinary person. The question is what effect did any drug of abuse consumed by the defendant have on him at the time and place involved. If the consumption of a drug of abuse so affected the nervous system, brain, or muscles of the defendant so as to impair to a noticeable degree his ability to operate the vehicle, then the defendant was under the influence. You'll need to know that for count 1, the ag vehicular homicide by way of a DUI, and you'll need to know that for count 5, the DUI charge. Is there any evidence to support beyond a reasonable doubt that Josh was under the influence of anything? Was his driving really that questionable? I mean, think of the decisions Josh had to make there. He avoided an accident in front of him. He maneuvered the car off the road. He got out of the car. He didn't fall. He didn't stumble. He didn't look like a person we think of. And when we talked in jury selection about what a drunk looks like and what a druggie looks like, Josh didn't look like any of those things. Was Josh under the influence? Did you see his brain or his muscles or his reflexes affected in such a way that you could say that? Did they prove it to you? Did they prove that to you beyond a reasonable doubt? Josh looked good. Josh passed the majority of the field sobriety test. These tests aren't magic. These tests aren't some kind of medical screening device that we can rely on. They're not computer tests. But they're the best we got. Cops say that if you can't walk a straight line and you give up all these clues, or if you can't hold your leg up for a long period of time, you give up all these clues. If your eyes twitch back and forth when he runs his finger in front of him. But Josh passed those. You can look at him. You can try those tests yourself, and I submit to you, they're not easy. They're not easy. And Josh looked great. The only test he really had a problem with was the touching your nose. And we heard from the expert that that test is not even to be used outside of the laboratory or outside of the controlled setting. It's not to be used. There's no indication that this methadone impaired Josh. Who should we look to for that information, by the way? Who's the best person to say whether or not this drug caused impairment? Josh's doctor. The state of Ohio called his doctor, and what did his doctor tell you? Methadone didn't impair Josh. It doesn't cause impairment. If it did cause impairment, shouldn't Josh's doctor be sitting there next to him in the chair?
Objection.
The doctor wrote the prescription. The doctor gave Josh that drug, administered it to him. So there's no opportunity for Josh to cheat and take more than he's supposed to. And the doctor testified for the state that...
Objection, Judge. That's not accurate.
He was called as a court's witness. He was not here on behalf of either party.
As you know, that's a correct statement of law. The state of Ohio questioned the doctor. I didn't. They asked him straight up about impairment. The doctor said, no, Josh is not impaired. This is an important case to the state of Ohio. They have the full weight, measure, and force of the government. They were able to fly half the Alabama DMV in here. How come they didn't have an expert witness to come in and say methadone causes accidents? How come they didn't have a scientist or a pharmacist or a toxicologist come in and say, yeah, he should never have been on that methadone. Everyone knows that causes accidents. Why didn't they have one? Why? They've got the money. They've got the resources. The case has been pending for 11 months. The only thing I can think is the science is so well settled that methadone doesn't cause impairment that they can't drag anybody in here that's willing to say anything different. Because if they could have, they would have.
Mr. Sen, that is your opinion. That is not part of the evidence, and it's not appropriate argument in this particular case, given what the discussions with the parties.
The only evidence that you heard of a medical nature was from Josh's doctor, an addictionologist, an addiction specialist, a guy who works in addiction. And he told you straight up, wouldn't cause impairment. Josh isn't impaired. So that whole impairment thing is a red herring, designed to lead you off the trail. It's not true. And I think you all know it's not true. I think you know the case fails for those reasons. The second way they try and get Josh is by saying he's reckless. There's another charge in here. Count 1 is the alcohol, or the DUI, driving under the influence, vehicular homicide. They have to prove that he's impaired, or under the influence, I should say, in order to get the vehicular homicide. They don't have that. So now they're hoping that they can get you on the reckless. They're hoping that you'll say, well, you know what? I don't think that they proved beyond a reasonable doubt that Josh was on this methadone and that it caused this accident, because it didn't. But they're hoping you'll come back and say reckless as if that's better, or that you're giving somebody a break. Josh isn't reckless. I want you to know what reckless is. A person acts recklessly when, with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk that the person's conduct is likely to cause a certain result or is likely to be of a certain nature. A person is reckless with respect to circumstances when, with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk that such circumstances are likely to exist. What we're talking about there is Josh's knowledge. In order to be reckless, Josh had to disregard a substantial known risk. He had to know that trooper was on the side of the road. That had to be a real risk, that in the middle of the day, there's going to be somebody on that berm, and if you hit it to avoid an accident, you're going to hit somebody. To constitute recklessness, one must act with full knowledge of the existing circumstances. Speed alone is not sufficient enough to constitute recklessness. Anybody think Josh had full knowledge? I mean, I think the state of Ohio might want you to believe that Josh saw a trooper there and decided it'd be better to hit him than not, but we know that's not true. Did Josh have full knowledge that trooper was there? Is it even reasonable to think that's a risk? In this situation, 3.9 seconds, and you've got to make a decision of where to put your car to avoid a wreck. Is it reasonable to assume that there might be a trooper standing outside of his car in the berm? Is that a risk that's foreseeable? Is that a risk that you should know about? Reckless is not this. Reckless driving, it's not drunk driving, it's not drug driving, but it's just as dangerous. Can texting be reckless? Maybe. Can driving, taking a shortcut down a one-way street the wrong way? Maybe. What about changing into your swimsuit from your work clothes, doing 65 down the freeway? That's reckless. That's what this law is designed for. People who are doing crazy stuff. Driving with the blindfold on. Speeding through construction zones. You know somebody's out there working and you're going to go speeding through there. We don't have recklessness here, and it's a serious charge. So I'm asking you not to just say, well, they didn't get him on the DUI, but let's give the state something because there's a man dead. Frankly, if you have to do that, and I don't think you have to, I think Josh has been through enough, but if you have to do that, then I'm asking you to look at the negligent charge. Because at best would you find the lesser included offense of negligence. And I'm going to read you what negligence is. If you got to go somewhere because you can't bring these folks and not guilty, here's where you go. A person acts negligently when, because of a substantial lapse from due care, he fails to perceive or avoid a risk that his conduct may cause a certain result or may be of a certain nature. A person is negligent with respect to circumstances when, because of a substantial lapse from due care, he fails to perceive or avoid a risk that such circumstances may exist. You'll have these instructions. I don't expect you to get them all now, but read them. If Josh did something wrong out there on that road, We all know he didn't try and pass in the berm. We all know that he didn't try and hit this trooper. But if you think there's some traffic problem that he did, you think he didn't use due care, then that's where you go. That's where you go. This was an accident, but he has some fault. I submit to you, I don't think he does, because I'm not sure what anybody could do different in that situation. They talk about him following too close, but there's no evidence of that. I get that it's easy to say, well, he hit somebody from behind, or he could have hit somebody from behind, or he didn't have enough time not to hit somebody from behind, so he's assured clear distance. Do you remember what the reconstructionist said? I mean, it takes 190 feet, 10 to 11 car lengths to stop from highway speed. Cars just can't stop instantly. It takes a while. Sometimes they lock up. Josh's car took 190 feet. Is it realistic for any of us to go out there and keep 11 car lengths between us and the next guy on 90? Is it realistic? They want you to believe it is. They want you to believe that when they drive home tonight, they're going to keep 11 car lengths between them and the car in front of them. And that Josh is some kind of crazed maniac that he won't do it. Come on. Come on, that's disingenuous. But if you think Josh did something wrong, maybe he could have been looking closer. Maybe he looked away when the brakes came on. Maybe he didn't see him. Maybe he wasn't paying attention. Maybe he dropped his cigarette. Who knows? If you think he did something wrong, you find him guilty of negligence. Won't hear us complain. That would be where this should have been all along. Anybody think that if a police officer wasn't dead, we'd be here?
Objection.
This driving under suspension stuff, that's just an example of them throwing everything at Josh they can throw. Everything. I want you to go back and when you get a chance to look at accident reconstruction. All you got to do is read page 5 of the accident reconstruction. Point 132. The accident reconstructionist, who frankly was a super honest guy. He came in and he was all facts. At the time of the crash, Mr. Gaspar had a valid Class D Ohio driver's license issued on May 23rd and expiring May 23rd, 2016, expiring May 21st, 2019. There are no restrictions listed. He also possesses a valid temporary permit, which was issued February 10th, 2016, and expires February 10th, 2017. He had a valid Ohio license. He had a valid Ohio license. Did they go back after the trooper was killed and dig into his applications and try and get his license taken away? Yeah, they did. Does that change the fact that at the time this happened, he had an Ohio license that was valid? No, it doesn't. Josh's license was suspended in Alabama for 6 months. The dates on that were sometime in August, the judge suspended it. August 2016. But then, no, I'm sorry, it'd be August 2015. I apologize. Sometimes in August 2015, the judge suspended it. Get that. Let me make sure I get that right for you. No, it'd be August 2016. Judge suspended it. But the BMV didn't send it. The Alabama BMV didn't send anything to Josh for months. So Josh left court with a 6-month suspension, but then in November the suspension came down. Okay, that's fine. 6 months. It would have been up May 20th. This happened in September. It was up May 20th. This happened in September. What they want you to believe is that somehow, because Josh had a problem in Alabama with his license, that his license here that was valid isn't valid. But what did Josh do? Josh did what any one of us would do.
Objection.
Sustained. Stick to the evidence of what the testimony was.
The BMV from Alabama said they didn't put a block in the computer. They just didn't put a block in the computer. Josh got a valid Ohio license. He did what he needed to do to get that Ohio license, and they gave him one. So this is another red herring, but there is something interesting about this charge that allows you to kind of discount it. I want to talk about that with you. I didn't really catch it in the beginning, but I've caught it now. Judge is going to read to you a lot about this specification about Josh missing his license, not having a license, and you could really spend time thinking about, well, it was in Alabama, but Ohio was valid, and we think we'd be okay there. But there's an interesting part to this jury instruction the judge is going to give you. I want you to read it, because all through these driver's license part. Furthermore, at the time of the offense, the offender was driving under a suspension or cancellation imposed under Chapter 4510 or any other provision of the Ohio Revised Code, or was operating a motor vehicle or motorcycle, did not have a valid did not have a valid driver's license, commercial driver's license, temporary instruction permit, probationary license, non-resident operating privileges, and here comes the part that I want you to focus on. And was not eligible for renewal of the offender's driver's license or commercial driver's license without examination. This jury instruction says that the only way Josh is suspended is if suspended by meaning of this, is if he was required to retest. If he was required to retake the examination. What do we know? We know that all he had to do was pay a fee. We know that all he had to do was pay $350. No one said he had to take another examination. No one said he had to retest. I know it's a little bit technical, but the judge is going to read it to you. It's right there. The evidence is this is just a money suspension. That's why the law is what it is. Don't you think that he could have just paid the $350 if he knew it was going to be this big of a deal? But would any of us pay the $350 to the state we used to live in if the state we're currently in gave us a license anyway? Would you send them that goodwill money? The law recognizes that there are different types of suspensions. They don't want people out there killing people in cars after they've done crazy stuff in their cars and have their license taken away. Those people have to go take the test again. Josh wasn't required to take the test again. All Josh would have had to do to be valid in Alabama is pay $300. I think the state missed this, frankly. And I think that every one of these counts is going to fail without you even having to think about whether or not Ohio's valid license is a valid license. Every one of those is going to fail because there's been absolutely no testimony that Josh is required to take an examination, and that's going to be right in there. Talk about throwing stuff at the wall. I can't even read some of these charges. I don't even know what they are. Prohibited acts. It sounds like they're accusing Josh of driving under suspension. Okay, I get it. Seems like they're saying that he forged his license and that he lied and he tampered with records. Where's all the evidence of that? Did anybody from the Ohio BMV come in and say Josh came up to my window and did this and this and this? I guess their idea is that by signing the form that somehow he knowingly committed a fraud. When you go to the BMV, you expect them to tell you what to do to get a license, and you sign the paperwork they give you. Josh's suspension had been up. He didn't pay the $350, but it was only 6 months. It had been way up. So the reality is, there's another red herring that they bring out to take you away from the truth. This is just an accident. Just a terrible, terrible, terrible accident. Talk about honesty involved. Page 100. Accident reconstruction report. Pull it out when you get back there. Look at that skid mark. Why isn't the government talking about that? Why aren't they bringing that up? Why wasn't that listed as a factor in the Ohio Highway Patrol's causation report? I get that we're saying the accident reconstructionist is an expert, but as far as everybody being too close to this scene, having your own agency investigate this scene, come on, you don't think that blue car had any part to play in this? You don't think that he should have been listed as a causation? If a guy slams right in front of you and stops in front of you, they don't even act like it happened. But yet, it's in their own paperwork. In their own paperwork. And we know it happened because we heard from some of the witnesses. We heard from the doctor. We heard from the attorney. What was his name? Attorney Mikowski. He heard screeching brakes. Looked to his left and saw Trooper Velez get hit. Heard the brakes. That is consistent with the blue Honda that we see in the video locking him up. in a manner that Josh didn't have time to get around them. But I'm going to talk about some of the other witnesses. Trooper K, first trooper on scene, over 700 OVI arrests. Saw no signs of impairment. First trooper on the scene, 700 arrests, saw no signs of impairment. The paramedic saw pinpoint pupils, but no other signs of impairment. We'd be worried if he didn't have pinpoint pupils. He takes a medication that causes pinpoint pupils. I don't know if that's aggravated by the fact there's bright sunlight out there, but we'd be worried that he wasn't doing the right thing if he didn't have the symptom that the medication gives you. I kind of think that's what happened here. I think that maybe, well, I know what happened here. A trooper got hit. People wanted answers. Someone started throwing around that Josh seemed impaired. People who didn't know the difference between shock and impairment. When I talk about like a mean prosecution or a misleading prosecution, to sit here and try and say to you that the fact that Josh didn't have emotion or Josh acted funny after this or didn't act the way you and I would act means that he must have been impaired. Come on, he's in shock. He just killed a guy. He just ran him over. And it was an accident, but he's in shock. But they want you to believe that somehow that's a sign that he's high and not acting right. It was BS. It's BS. I couldn't figure out why, when I talked to the sergeant about the field sobriety test, why he was so stuck on saying that Josh failed the test when we looked at the video and they didn't. And he battled me. And ultimately, the expert that came in contradicted him. He said things like, well, we don't really look at the clues. The clues aren't really important. Bull. The clues are there. You've been trained on the clues. You teach the clues. The clues are very important. The indicators are very important. Why wasn't he paying attention to those? And I think I figured it out. The trooper's dead. They have a guy there with pinpoint pupils and is in a methadone program, which they know enough about to know that means he had a drug problem. Does anybody here think there's any way that guy's not taking a blood test? Is there any point that he's not going to be forced to take a blood test?
Objection.
Is there a point that the troopers are going to say, no, he looks good to me, send him on his way? He's taking a blood test. And he agreed to take a blood test, but they were so concerned that they wouldn't get one, because it's a time thing, that they went and got a search warrant anyway. They went and got a backup search warrant to get that blood. They didn't do the fancy DRE test that they wanted to do, or they should have done, I should say. They didn't do that because they wanted that blood.
Objection.
He's saying a jury can disregard that. The search warrant is a lawful thing to get in many investigations. Don't speculate. Just move on to talk about the evidence.
The evidence is they went and got a search warrant. The evidence is they had to go in front of a judge to get it. And the evidence is that they have indicated that Josh failed the field sobriety test. And there's your reason for saying that he failed when he didn't. Because they had to have that test. And when they found out days later that the test came back without drugs in it, that's when things should have changed. That's when they should have said, wait a second. This is an accident. When the accident reconstructions got done months later and said, the speed's not 70 or 80, it's 62 to 65. This is an accident. That's when the prosecution should have said to the Ohio State Patrol, this is an accident. But instead, they doubled down. They doubled down, they added more charges, and they took his driver's license, and they threw everything at the wall. And that's where this prosecution is wrong. That's where it got mean. More witnesses we heard from. Kristen Baker is PO in Alabama. No problems with Josh. Deanna Pregno, Alabama BMV. He could reinstate May 20th of 2016. Just need to pay a fee. Trooper Thorne, OSP. Nice guy. Now they must wear an orange vest when on the side of the road. Think about that. If it's not dangerous to have a police officer out there doing traffic without wearing a vest, why'd they change the policy? Why'd they change the policy? Trooper Gable came in and fought with me about how the tests were important, but you heard an expert come in, a GRE. And yes, he testifies for the defense. How's he going to testify for the state? He's not a police officer. Police officers testify for the state. He's not a police officer anymore. He testifies for defense. But he teaches, and he's good at what he does. He's got a lot more experience than the trooper, and he's not related to, by work friendships to the dead officer. And what he told you was, Josh is not impaired. And you should know everything you need to know about their case and what they know and what they don't know by the fact that they start talking about caffeine. Come on. If they don't know what impaired him, how can they expect to prove it to you? They're going to start talking about Monster energy drinks, and maybe as Trooper Gable said, maybe the blood test and the urine test that was done within 2 hours somehow doesn't show all the drugs he was on. Maybe he was on a designer drug. That's BS. And if they don't know it, how can they prove it to you? They can't. They can't. The fact that they went to caffeine is sad. It's sad for the trooper's family, and it's really sad for Josh. Toughest witness for the defense was the nurse that came in the end. Because she doesn't like methadone. She doesn't work there anymore. She doesn't like methadone. And I asked her questions I didn't know the answer to, and she said things like, "Oh, I don't recommend methadone. Those people are drug addicts. They don't do counseling." She clearly doesn't think methadone's a way to treat this opiate epidemic. That was who they brought in to counteract the testimony of a doctor? That was what they brought her in. To try and counteract the testimony of a doctor. That's their big medical evidence. A disgruntled nurse who said Josh was compliant. I get this methadone is controversial. I get it. It's a controversial thing. We're in the middle of an opiate epidemic. We've got people dropping dead all over the place, so we're trying to come up with ways, and we've been coming up with ways for 40 years to deal with it, and methadone is a way. It's a safe way, and the doctor told you. It's safe, it's well tested, doesn't cause impairment. Are we keeping these people hooked on something for the rest of their life? If you get high blood pressure, you're going to take high blood pressure medicine. If you have heart problems, you're going to take heart medicine. If you're an opiate addict, you're going to take a medicine that blocks the opiate receptors. And if you have to take it for the rest of your life in order to lead a productive life, then you do it. But I get that it's uncomfortable because this is something that drug addicts use. This isn't something that we use in our daily life. Just like depression used to be something we hid and taking antidepressants and bipolar medicine, we didn't talk about it. That's what we're doing with the opiate. Don't want to talk about it. This makes it dirty. This makes it dirty. Folks who are out there getting help with this addiction, now they make it seem as if it's unsafe to drive on. Might go out there and kill somebody. Make crazy, reckless decisions. It's not true. It may not be the way you treat it. You may go a different direction, but it's legitimate. It's a prescription. And it had nothing to do with the impairment. Look, 10 minutes later, is that even in his body in 10 minutes? If I drink a beer, am I feeling it now? Or am I feeling it 20 minutes from now? And this is a liquid he takes. They want to make a huge deal out of 10 minutes. 10 minutes, and he hits a trooper. Well, 3 minutes before he was smoking a cigarette. Could the cigarette cause this? It's all red herring. It was designed to dirty Josh up. If you think he's got a drug problem, if you think he's got a prescription pill problem, you'll think he'd just as likely kill a cop and try and run on the side of the road. Try and drive in the emergency lane. And it's wrong. It's really wrong. When we did jury selection, we talked, and the Team Innocent thing I brought up is a little bit corny, but it's realistic. You are the only thing that stands between this prosecution and Josh. For 11 months, there's been no you. No one to pull this thing apart. No one to answer the cries of cop killer, murderer, drunk driver. We've been waiting for you. You stand between them, and in order to get to Josh, they have to go through you. And the law says he's presumed innocent. And the law says they have to prove it to you beyond a reasonable doubt. I talked to you about sports teams and jury selection, and talked about what would it take you to pull off that jersey, put on the other team's jersey. How much evidence would it take? And it's an easy way to look at the fact that Josh is presumed innocent, and you've accepted that. Have they got you to pull off your jersey? Have they got you to the point where Josh is guilty? Are you firmly convinced? That's beyond a reasonable doubt. It's a high burden. You have to be firmly convinced in the truth of their evidence. So much so that you'd rely on it if it were your most important affairs. This is heavy stuff. When you go back to the jury room, you're not back there trying to establish evidence of guilt. You're back there looking for reasonable doubt. That's what team innocence is all about. That's what presumption of innocence is all about. That's what the law is all about. You're back there looking for reasonable doubt. You know, at the end of this thing, which is shortly, if you believe everything that their witnesses said, then go ahead, find Josh guilty. If you don't believe a word their witnesses said, you go ahead. That's doubt. That's reasonable doubt. And if you have reasonable doubt, there's only one verdict you can bring back. And that's not guilty. And I'm asking you not to do the obvious, not to just throw out the DUI because they didn't prove it and go ahead and say recklessly. I'm asking you to look at the evidence, to read these jury instructions, because these charges are serious. And this is a serious prosecution. And for you folks, it's been a hard 2 weeks. 2.5 weeks. I came in, it's a hard 2.5 weeks. For us, this is a job we do. For the judge, this is a job he
Thank you, Judge. Counsel. You saw the overhead picture of that approach to that mile marker. And it's in the exhibit, which is state 647. Page 13. Please pay attention to that. Is it a sudden curve in the road with a trooper hiding behind the curve? No, it's not. Recall Jester's testimony. There were no deceptive enforcement practices by Velez. There was no fault by Ken Velez. Put yourself going down the highway with your eyes on the road, where they belong. In that video, blue Honda, trooper. Oh, you know what? I don't want to wreck my new Veloster, so I'll avoid the Honda and pick the pedestrian. Because if you see the pedestrian, that's the logic that you're given, that you tried to avoid the Honda. Who would make that choice as a reasonable motor vehicle operator? I'm going to strike and kill the trooper to avoid the Honda. Because I see the trooper and I see the Honda. No. The only reasonable explanation of that event is you're focused on the Honda and you don't see the trooper. But yet there's nothing visually blocking your view of the trooper. So how does that come about? We've all seen on TV these incidents, like the train approaching the deadly curve. I think it was in New York. And the overhead camera has the operator texting seconds before. Your failure to apprehend an approaching risk because your attention is elsewhere is reckless, because you're not doing your job as an operator of the motor vehicle. Your physical condition, a prescription to be under a doctor's care for opioid addiction, fine. Is that a license to drive? Don't fall into this trap of the mischaracterizations of what Attorney Sin, I submit, are mischaracterizations of DeFranco's testimony. He was called as a court's witness. You heard the judge instruct you, he's neither party's witness. What you saw us do was a cross-examination. Recall his demeanor when he was forced to admit certain things. And you got those slow, reluctant yeses to my questions. And what were they? And again, this is a technical area. You're going to have physical copies of that black box warning of what methadone is, and all the things that DeFranco was forced to admit it can do. This is not a case of someone who was stabilized on their dose. This is not a case of a person who was demonstrably compliant with their course of medical care. The record shows the exact opposite. From Nurse Bradovanic's testimony, you revisited the dose history that we showed to DeFranco. What do we know? On the 9th, the defendant is complaining he's under-medicated. He's in withdrawal. Positive W/D. That's the 9th. Nurse, what would a patient under those circumstances be feeling to justify a dose increase? Well, he'd be getting sick. He'd be feeling nausea. He'd be dope sick because he's having symptoms of withdrawal. So he complained on the 9th. Dr. DeFranco wrote the increase. So of course you come back next day to get relief, right? The 10th. Sorry, wrong. Not there. The 11th. No, sorry. And what's going on is this half-life issue of the drug. That's very, very important. You're not stable on the dose, and even DeFranco was forced to admit it, until 5 to 6 days have passed. And by stable, that means you're not going to experience dose initiation side effects. And what were those, potentially? Euphoria. Methadone can give you a high. It's not some innocent drug in place of the opioid. It's an opioid itself. Sedation. Impaired judgment. Bad decision making. Decreased reaction time. When you look at that dose history for the 4 days, including the day of the crash, by definition, he's not stabilized. A agonist, you'll remember that technical term, and I'm going to use my fingers as the neural receptors as a metaphor. A full agonist is that if heroin hits your brain receptor on all the available points in that nerve, so does methadone. It's a full agonist. Suboxone, for example, a more modern drug, is going to hit partially. 2 or 3, but not full. Why is that relevant? The nurse said, well, you know what? I've seen patients there that have been on methadone for 35 years. So, to the extent society has a heroin problem, an opiate problem, an oxycodone problem, nobody should have to not have medical help needed under the modern medical theory that drug addiction is a disease that should be medically treated. That's fine, no quarrel with that. The question is, you have to follow your doctor's orders in order to throw the blanket of immunity over yourself to say, I had a prescription. That's not what this evidence demonstrates. It demonstrates the opposite. So ask yourselves to fill in the blank circumstantially based on the nurse's testimony. For those 2 days without the methadone, did the cravings go away? Did the nausea go away? Did the dope sickness go away? What's going on during those 2 days? Ask yourselves that. Combine that with the photos of the floorboard of the car. You've got an open container of Monster, which again, here we're going to be technical. Monster's heavy dose caffeine, somewhere in the range of 3 or 4 cups of coffee in one 16-ounce can. It's a stimulant. We're not trying to blame it on the Monster. It is important when you evaluate Gable's description and then the magic bingo card of cross out this box, cross out that box, and so on. They never filled up their bingo card. I never heard of bingo. They were attempting to mislead you that there's some sort of pass-fail test here. Even Palacios admitted. These are investigative indicators that the trained observer uses to make the evaluation. Ultimately, it's the trained observer, the roadside sobriety law enforcement individual, who renders a judgment on impairment or not. So antagonist, you've got a stimulant and a depressant. Is that going to mix up the signals? That was the testimony, plain and simple. Yes, it would. So, why would Gable reach the conclusions he reached? Wouldn't you expect if he's not impaired, there would be Good Samaritan testimony from the roadside that was of a different character than what you heard? Oh, and he says, and Kay says, no observation of impairment. Kay ran up to the guy, asked for his ID, and handed it off. That's all he did. Let's not misrepresent Kay's involvement here. That's what Kay did. He was responding there's a man down, bleeding to death. I need to find out who that operator is and get his ID to the responders. That's all Kay did. Paramedic, nurse, doctor, arroyo, anger. What does it take to somebody who has just observed what we all observed via video to go from concern for the injured to anger? That interaction of something's not right here. You can't recreate those moments. You can't put them under a different light than what they were. Those people had honest, genuine reactions to what was in front of them. And what was in front of them was an impaired driver, Joshua Gaspar. Acting inappropriately, pinpoint pupils, apathetic, lack of concern for Trooper Velez. Recall the stipulation, State 1625. You haven't heard much about it, but you're going to have it in evidence. There's 2 flags on it. They're there for your convenience, but even if they're not when you receive it, you'll turn to the page 915, 1230. There's a significant gap, and then at 1235, there's phone activity. I would submit to you that that corresponds with phone activity at CAAA after the dose is administered, but before the trip starts, or as it's starting. Okay? Remember the nurse's testimony, how many lights there are to go north on 55th. And you've got to make the mandatory right because of the new median for RTA that's in Euclid Avenue. So you got to go around the block, and either go down to 40th and find your way north to the highway, or you come back to East 55th and then proceed north to the Shoreway. 10 minutes. 12:34 to 12:44. Mario Andretti would have a hard time obeying the laws and making that time. So you then turn the page, and you're going to see on the second flag, 915, 1244, you're going to see data activity. And then call activity at 1244, and then continuing after at 1245. It's for you to conclude, was there inattention due to what factor? Was it a combination of, you just took an opioid, you're driving too fast, there's a cigarette butt on the floor, there's an empty can on the floor, what's going on in the car? Everybody else that saw this traffic enforcement, whether they were confused or not as to who or what Velez was flagging, did what? They controlled their vehicles. They stopped safely. Who didn't? The person whose attention by this set of evidence was obviously somewhere else because his slowing started too late. His overtaking speed was too great for him to successfully stop. The only reasonable explanation for that is eyes not on the road. And you pick up the threat too late because you were just on your phone or looking for your cigarette butt or reaching for a can of Monster. But that's what this evidence circumstantially demonstrates. This is not a case of negligence. This is a case of impairment. This is a case of recklessness. And all the evidence points to it. On the subject of methadone impairment, You did not hear and did not see a charge of a per se violation like you might with alcohol, .08 or above. That's a per se violation, a blood level or urine ticket, if you will, or charge. Because the law doesn't contain one for methadone in Ohio. It's a separate issue, it's a public policy issue, but it doesn't change the fact that methadone is a totality of the circumstances offense in this question before you. That's why the trooper was correctly, I submit, stating to you his observations as what it was, considering the road, the vehicle conditions, the bystander's observations, and my interaction with the operator. All of that together at the end of the day is impairment. That's an appropriate conclusion based on this evidence. Oh, there should be 3 parties here. Why isn't, well, actually 4 if you accept John's argument. Not only should we have the blue Honda here, but we should have Dr. Franco here, charge 2. I asked Gesture, if the Honda did something unexpected, and we all know this from our own personal experience, it doesn't matter what the car in front of you does. If you strike it, if you rear end it, it's not their fault, it's your fault as the operator, failure of assured clear distance. And that is what you see in 1626. As Aquila showed you, the extract from the crash report cites factors of Unit 1, which is Gaspar, followed too closely, improper lane change. Velez, the pedestrian, no fault, none. If you see the risk of the pedestrian, if it's the person with the flat tire at the side of the road, and there's a car stopped in front, do you choose the pedestrian? Going 60 plus miles an hour? That's not a rational choice. It's not a reasonable choice. It's a reckless choice. It's an impaired choice. Josh looked good. Wow, not to McGaw. McGaw was a damn good EMT. You saw his demeanor, you saw his professional knowledge, you saw his articulate way he handled the questions that were put to him. He was immediately concerned, and he wasn't going to leave that scene without reporting to not one law enforcement agency, but both, Lakewood and the patrol. You've got an issue over here. I think he's impaired, or words to that effect. Petrie, 40-year RN. Religious person, moral person, but again, like Arroyo, angry. What are you on? You're on something. Even with that anger, she collected herself and said, we got to pray for him, too. Not just Trooper Velez, but we got to pray for Gaspar. What does that say about her character? Do you think she'd come in here and make a false accusation? Her credibility? And returning to McGaw, do you find fault with his credibility? Look for it. Tell me where it is. This isn't an accident. This is a series of decisions and personal responsibility that the law properly calls into question as criminal conduct. That's what this is. Is it mere negligence, as John invites you to conclude? Mere negligence is a violation of a duty of care owed to someone else. Very much like civil law, okay? It's a violation of a duty of care. Is that all this is? A violation of a duty of care? Or does all the other things that we've been talking to you about, the impairment, the methadone, the speed, the clear point of view. Remember, when you look at that rear view camera, it's got a direct line of sight to the front of the black Veloster. And you know the reverse is true. So there's nothing hidden here from his ability to see a known risk in front of him had he chosen to been doing his job as an operator. The simple fact is he wasn't. He's impaired, he's inattentive, and he's going recklessly fast. The furthermore on each of these counts, understand and be clear. Each of your votes stands alone in the sense that if you should find guilt on impairment or guilt on recklessness, you then turn to the next question of the furthermore. If for whatever reason you decide the furthermore doesn't apply, that does not go backwards and affect your earlier finding that the state has proven its case on impairment or recklessness. The furthermore is about the Alabama issue. So, if two twins go into the bureau, Jimmy and Johnny Smith, and Johnny has a horrible record, and his license is gone. And he says, I'm Jimmy Smith. And the bureau doesn't catch it and issues a license card. Is that a valid license? No, it's obtained under false pretenses, period. The obligation, you heard the testimony, the obligation is on the applicant, the operator, to declare their legal status. It's not a case of, gotcha, catch me if you can. It's, where does the responsibility lie? Just like for being an operator on the roadway. The responsibility lies with the applicant, not with the clerk behind the counter. He lied, plain and simple, to obtain an Ohio license. For whatever purpose, for work, who knows? But it's self-evident from this testimony, this record, that Ohio application, he lied to Ohio. He did not have a validly issued Ohio license. He obtained it under false pretenses. He's guilty of the furthermore. And as to the status of Ken, stipulation number 1, first day of testimony, the parties stipulate and agree that he was in uniform, in a marked vehicle, and going about the course of his duties. The specification is stipulated to as to Ken's status. It's not an issue. So the first test, 670 nanograms per milliliter, methadone positive. The second test, 711 nanograms per milliliter, positive methadone. John says, well, so he drank the cup and 10 minutes later they want you to believe he's positive. I showed DeFranco a medical study that showed the metabolic uptake, the curve, and yes, the peak is 1 or 2 hours later, but the ingestion of an oral dose of methadone is immediate, the uptake. Don't be confused by the issue of the societal problem with heroin in general. This case is no different than somebody who, you could be a cancer patient and have a valid prescription for oxycodone or morphine. and be within the legal permission of taking that drug because it's prescribed by your physician. But that doesn't mean that you're automatically a fit operator. Remember that. How many times have you seen a warning label? Do not do this, that, or the other thing on this medication. Don't make the automatic leap just because doctor says you can have this drug, that means okay to drive. Investigative bias. Oh, everybody is just here because one of their own was killed. Is that what you saw in the testimony? Do you think Jester? I don't recall any deep and personal relationship between Jester and Ken Velez. Jester delivered a very professional, very expert crash reconstruction that detailed the things that we've talked about in State 647 and State 1626. Oh, Cleveland should have done it. I'm not going to belittle Cleveland, but this is 170 pages long. It's detailed, it's accurate, it's thorough. And the conclusion is Ken Velez isn't responsible for Ken's death. Gaspar is. From the testimony, in addition to the report, you know he was impaired, and you know he was reckless. Don't let these insults to the memory of Ken Velez blind you to the reality of the evidence. We ask you for verdicts of guilty on all charges, furthermores, and specifications. Thank you.
Ladies and gentlemen, you've been sitting a long time, so we have a 5-minute restroom break, and then we're going to go immediately back in to the part where I read the instructions. The driving under the influence provisions in count 5. So you'll have to, we don't get to those till later, but you understand they count for, you need them for count 1 as well, okay? Also, there are some definitions in count 6, the driving under suspension, that come into play in some of the further findings that are given to you earlier. So those same definitions apply, so all the instructions are to be considered as a whole, no matter what order you might get them in. They all have a place where they go, okay? So members of the jury, you've heard the evidence and the arguments of counsel. It now becomes my duty to instruct you on the law that you're to apply to this case. The court and the jury have separate functions. You decide the disputed facts, and the court provides the instructions of law. The instructions are to be taken or read as a whole. It's your sworn duty to accept these instructions and apply the law as it's given to you. This you're required to do apart from any notion or opinion of any kind which you may have as to what the law is or what the law ought to be. It follows that, in strictly keeping with your oath, that you refuse to be influenced by considerations such as sympathy, bias, or prejudice for or against either the state of Ohio or the defendant in this case, Joshua Gaspar. You know that a criminal case begins with the filing of an indictment by the grand jury. This indictment informs the defendant that he's been charged with a crime. It may not be considered for any other purpose. Plea of not guilty is a denial of the charge and puts into issue the essential elements of the crimes charged in the indictment. You're instructed that opening statements and closing arguments do not constitute evidence. Also, you must not speculate as to why the court sustained an objection to any question or what the answer to the question might have been. You also must not draw any inferences or speculate on the truth of any suggestion included in a question that was not answered. Every person accused of an offense is presumed innocent until proven guilty by evidence beyond a reasonable doubt. The legislature of Ohio has defined reasonable doubt as follows, quote, reasonable doubt is present when the jurors, after they have carefully considered and compared all the evidence, cannot say they are firmly convinced of the truth of the charge. It is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything related to human affairs or depending upon moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of the person's own affairs." End quote. In this case, as in all other cases, it is the quality of the evidence that must be given primary consideration by you. The quality of the evidence may or may not be commensurate with the quantity of evidence, that is, the number of witnesses or exhibits presented. Whenever reference is made to evidence upon which this case is to be decided, the jury will understand that we mean testimony from the witnesses, exhibits admitted during trial, and any facts agreed to by counsel. You have had some of those. The attorneys have talked with you and pointed out stipulations which you may, in this case, accept without further proof. You know that evidence may be either direct or circumstantial or a combination of both. Direct evidence is testimony given by a witness who has seen or heard the facts to which he or she has testified. It includes the exhibits accepted as evidence during the trial and any stipulations. It's also known as direct, positive, or eyewitness testimony. It's not always possible to ascertain the truth by evidence of this direct character. Thus, the law permits the introduction and consideration of what is called circumstantial evidence. By circumstantial evidence, we mean proof of certain facts and circumstances from which the jury may infer other connected facts, which usually and reasonably follow according to the common experience of mankind. Circumstantial evidence and direct evidence inherently possess the same probative value. In some instances, certain facts can only be established by circumstantial evidence. Ladies and gentlemen, you are the sole judges of the facts and the credibility of the witnesses and the weight to be given to the testimony of each witness. To weigh the evidence, you must consider the credibility or believability of each person testifying. In doing so, you will apply the test for truthfulness which you apply in your daily lives. In determining the credibility of the witnesses, you should consider the interest or bias the witness has in the outcome of the verdict, his or her appearance, manner, and demeanor while testifying before you, candor and frankness, the consistency of the witness's testimony with other known facts in the case, accuracy of memory or inaccuracy of memory, intelligence or lack thereof, the reasonableness of the testimony, the opportunity the witness had to see or hear or know the truth of the facts and circumstances concerning the things to which he or she has testified, and any and all other facts and circumstances surrounding the testimony which, in your judgment, would add or detract from the credibility and weight of the testimony. Applying these tests, you will assign to the testimony of each witness such weight as you deem proper. You're instructed that you're not bound to believe something to be a fact simply because it was testified to by a witness who was under oath. You may believe all, part, or none of a witness's testimony. And keep in mind, I had talked with you earlier, representations made by counsel for either party, unless the witness testified to it, that doesn't count, all right? It's the witness's testimony that's paramount here and which must be considered by you. It's not necessary that the defendant, Mr. Gaspar, take the witness stand and testify in his own defense. He has the constitutional right not to testify. The fact that he did not testify must not be considered by you for any purpose whatsoever. We had some here who may be considered expert witnesses. Normally, a witness may not express an opinion. However, one who follows a profession or a special line of work may express his or her opinion because of his or her education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you arrive at a just verdict. Questions have been asked in which an expert witness was permitted to assume that certain facts were true and to give an opinion based on that assumption. You must decide whether the assumed facts on which the expert based his opinion are true. If any assumed fact was not established by the greater weight of the evidence, You will decide the effect of that failure on the value of the opinion of the expert. Questions have been asked of an expert witness after he or she has disclosed the underlying facts or data. It's for you, the jury, to decide if such facts or data on which he based his opinion are true, and you will decide the weight to be given to such evidence. As with other witnesses, on you alone rests the duty of deciding what weight to give to the testimony of an expert. In deciding its weight, consider the expert's skill, experience, knowledge, veracity, familiarity with the facts of this case, and the usual rules for testing credibility or believability in deciding the weight to give to the testimony. You'll have with you in the jury deliberation room the verdict forms and all the exhibits offered and admitted into evidence during the course of the trial. During your deliberations, the court reporter will not be permitted to read back to you any portion of any of the trial testimony. Now keep in mind, just because items were referred to or shown to a witness does not mean that they'll be going back with you to the jury room, all right? The court and the parties have talked about this matter, and I've decided what evidence will be going back with you, all right? So don't worry about what's not there. Focus on the value, if any, of what is there. Also, the firearm that was referenced will not be coming back to the jury room, okay? And for some of the evidence, there may be necessary to use a computer to view or to listen to things, and it will be a computer that we're providing that has no ability for outside internet, and it shouldn't have other things on it either. So that will allow you to view evidence here, but not have any outside contact or any improper undue influence, okay? If you would be in there and find out that there is something on there, let us know immediately, and we'll have our IT group get you another computer, okay? There are multiple counts. If you find that the state proved beyond a reasonable doubt all the essential elements of any of the offenses charged in the separate counts of the indictment, your verdict must be guilty as to such offense or offenses according to your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of any one of the charges charged in the separate counts of the indictment, your verdict must be not guilty as to such offense or offenses. The charges set forth in each count in the indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your finding as to each count uninfluenced by your verdict as to the other count. The defendant may be found guilty or not guilty of any of the offenses charged. And the same goes for specifications. I'm going to talk with you now about the indictment. Defendant Joshua J. Gaspar is charged in count 1 of the indictment with aggravated vehicular homicide in violation of Revised Code Section 2903.06A1A. Before you can find the defendant guilty of aggravated vehicular homicide, you must find beyond reasonable doubt that on or about the 15th day of September 2016 in Cuyahoga County, Ohio, the defendant did, while operating or participating in the operation of a 2015 Hyundai Veloster motor vehicle, caused the death of Ohio State Highway Patrol Trooper Kenneth Velez as the proximate result of committing a violation of Division of Ohio Revised Code Section 4511.19A1A, driving under the influence, or of a substantially equivalent municipal ordinance. Furthermore, at the time of the offense, the offender was driving under a suspension or cancellation imposed under Chapter 4510, the Motor Vehicle Offenses, or any other provision of the Ohio Revised Code. That's one alternative. This is actually in the disjunctive. So I'm instructing you. All right? So that was one possibility. Or was operating a motor vehicle or motorcycle, did not have a valid driver's license, commercial driver's license, temporary instruction permit, probationary license, or non-resident operating privilege, and was not eligible for renewal of the offender's driver's license or commercial driver's license without examination under Section 4507.10, the examination for a temporary permit, license, or endorsement exceptions of the revised code. All right, so that, furthermore, is in the disjunctive. It can either be that first situation I read to you, or there's a comma, or it could be the second situation, or none. I mean, you have to decide. The term operate means to cause or have caused movement of a vehicle. The term motor vehicle means any vehicle that is propelled or drawn by power other than muscular power and includes an automobile such as a Hyundai Veloster. The state charges that the act or failure to act of the defendant caused the death of Ohio State Highway Patrol Trooper Kenneth Velez. Cause is an essential element of the offense. Cause is an act or failure to act which, in a natural and continuous sequence, directly produces the death of a person, and without which it would not have occurred. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act or failure to act. The defendant is also responsible for the natural and foreseeable consequences or results that follow in the ordinary course of events from the act or failure to act. There may be one or more causes of an event. However, if a defendant's act or failure to act was one cause, then the existence of other causes is not a defense. The defendant is responsible for the natural consequences of the defendant's unlawful act or failure to act, even though death was also caused by the intervening act or failure to act of another person or agency. The death is the result of the defendant's act or failure to act when it is produced in a natural and continuous sequence and would not have occurred without the act or failure to act. For count one, there's a requirement that this was the proximate result of committing a violation of 4511.19A1A. So, a violation of Revised Code Section 4511.19A1A is defined under count 5, and the same definitions and elements apply here and must be proven beyond a reasonable doubt. Okay? So, count 5 elements apply to the charge in count 1, and it's the same burden of proof and it's the same definitions. Right? If you find the state proved beyond a reasonable doubt each and every one of the essential elements of the offense of aggravated vehicular homicide as charged in count 1 of the indictment, your verdict must be guilty according to your findings. You will then indicate your finding on the verdict form. If you find that the state failed to prove beyond a reasonable doubt any one or more of the essential elements of the offense of aggravated vehicular homicide as charged in count 1 of the indictment, your verdict must be not guilty according to your findings. You will then indicate your finding on the verdict form. As you're aware, there is a further finding with count 1. If your verdict is guilty of aggravated vehicular homicide as charged in count 1, you must decide beyond a reasonable doubt whether the defendant was guilty or not guilty of driving under a suspension or cancellation imposed, or was operating a motor vehicle or motorcycle, did not have a valid driver's license, commercial driver's license, temporary instruction permit, probationary license, or non-resident operating privilege, and was not eligible for renewal of the offender's driver's license or commercial driver's license without examination. You will then indicate your finding in the verdict form, page 2. And this issue of driving under suspension or cancellation, there are definitions that are given in count 6, which is awkwardly denominated as motor vehicle offenses. It's more commonly known as driving under suspension. Okay, so some of the instruction or some of the definitions you need for this further finding will be given to you, and they're in count 6, and you apply them back to this further finding. Okay. So you will indicate your finding on the verdict form, page 2. If your verdict is not guilty, you will not consider this issue. The term motor vehicle has been previously defined, and the same definition applies herein. There's also a specification with count 1. under 2941.1414A. If your verdict is guilty of aggravated vehicular homicide, you will separately determine whether the state proved, beyond a reasonable doubt, that the defendant's victim, Ohio State Highway Patrol Trooper Kenneth Velez, was a peace officer or was an investigator of the Bureau of Criminal Identification and Investigation at the time of the aggravated vehicular homicide as charged in count 1 of the indictment. The term peace officer means an Ohio State Highway Patrol Trooper. For count 2, defendant Joshua J. Gaspar is charged in count 2 of the indictment with aggravated vehicular homicide in violation of revised code section 2903.06A2A. Before you can find the defendant guilty of aggravated vehicular homicide, you must find, beyond a reasonable doubt, that on or about the 15th day of September 2016 in Cuyahoga County, Ohio, the defendant did, while operating or participating in the operation of a 2015 Hyundai Veloster motor vehicle, caused the death of Ohio State Patrol Trooper Kenneth Velez recklessly. Furthermore, at the time of the offense, the offender was driving under a suspension or cancellation imposed under Chapter 4510 of Motor Vehicle Offenses, or any other provision of the Ohio Revised Code, or was operating a motor vehicle or motorcycle, did not have a valid driver's license, commercial driver's license, temporary instructional permit, probationary license, or non-resident operating privilege, and was not eligible for renewal of the offender's driver's license or commercial driver's license without examination under Section 4507.10. The terms operate, motor vehicle, and cause have been previously defined and the same definitions apply herein. A person acts recklessly when, with heedless indifference to the consequences, the person disregards the substantial and unjustifiable risk that the person's conduct is likely to cause a certain result or is likely to be of a certain nature. A person is reckless with respect to circumstances when, with heedless indifference to the consequences, the person disregards the substantial and unjustifiable risk that such circumstances are likely to exist. To constitute recklessness, one must act with full knowledge of the existing circumstances. Speed alone is not sufficient enough to constitute recklessness. The term risk means a significant possibility, as contrasted with a remote possibility, that a certain result may occur or that certain circumstances may exist. If you find that the state proved beyond a reasonable doubt each and every one of the essential elements of the offense of aggravated vehicular homicide as charged in count 2 of the indictment, your verdict must be guilty according to your findings. You will then indicate your finding on the verdict form. If you find that the state failed to prove beyond a reasonable doubt any one or more of the essential elements of the offense of aggravated vehicular homicide as charged in count 2 of the indictment, your verdict must be not guilty according to your findings. You will then indicate your finding on the verdict form. This is for the further finding. If your verdict is guilty of aggravated vehicular homicide as charged in count 2, you must decide beyond a reasonable doubt whether the defendant was guilty or not guilty of driving under a suspension or cancellation imposed, or was operating a motor vehicle or motorcycle, did not have a valid driver's license, commercial driver's license, temporary instruction permit, probationary license, or non-resident operating privilege, and was not eligible for renewal of the offender's driver's license or commercial driver's license without examination. You will then indicate your finding on the verdict form, page 2. If your verdict is not guilty, you will not consider this issue. Motor vehicle has been previously defined and the same definition applies herein. Now the specification under 2941.1414A. If your verdict is guilty of aggravated vehicular homicide, you will separately determine whether the state proved beyond a reasonable doubt that the defendant's victim, Ohio State Highway Patrol Trooper Kenneth Velez, was a peace officer or was an investigator of the Bureau of Criminal Identification and Investigation at the time of the aggravated vehicular homicide as charged in count 2 of the indictment. Peace officer has been previously defined and the same definition applies herein. Now this speaks to the purpose of submitting a lesser offense on count 2. If the evidence warrants it, you may find the defendant, Joshua J. Gaspar, guilty of an offense lesser than that charged in the indictment in count 2. However, notwithstanding this right, it is your duty to accept the law as given to you by the court. And if the facts in the law warrant a conviction of the offense charged in the indictment, namely aggravated vehicular homicide in count 2, then it is your duty to make such finding, uninfluenced by your power to find a lesser offense. This provision is not designed to relieve you from the performance of an unpleasant duty. It is included to prevent failure of justice if the evidence fails to prove the original charge, but does justify a verdict for the lesser offense. This covers the lesser included offense of vehicular homicide. If you find the state of Ohio proved beyond a reasonable doubt all the essential elements of the offense of aggravated vehicular homicide in violation of Revised Code Section 2903.06A2A, your verdict must be guilty as charged. If, however, you find the state failed to prove beyond a reasonable doubt any of the essential elements of aggravated vehicular homicide, then your verdict must be not guilty of that offense, and in that event, you will continue your deliberations to decide whether the state has proved beyond a reasonable doubt all the essential elements of the lesser included offense of vehicular homicide. If all of you are unable to agree on a verdict of either guilty or not guilty of aggravated vehicular homicide, then you will continue your deliberations to decide whether the state proved beyond a reasonable doubt all the essential elements of the lesser included offense of vehicular homicide. The terms operate, motor vehicle, and cause have been previously defined, and the same definitions apply herein. A person acts negligently when, because of a substantial lapse from due care, he fails to perceive or avoid a risk that his conduct may cause a certain result or may be of a certain nature. A person is negligent with respect to circumstances when, because of a substantial lapse from due care, he fails to perceive or avoid a risk that such circumstances may exist. Before you can find the defendant, Joshua J. Gaspar, guilty of vehicular homicide, you must find, beyond a reasonable doubt, that on or about the 15th day of September 2016, and in Cuyahoga County, the defendant did, while operating or participating in the operation of a 2015 Hyundai Veloster motor vehicle, caused the death of Ohio State Highway Patrol Trooper Kenneth Velez negligently. Furthermore, at the time of the offense, the offender was driving under a suspension or cancellation imposed under Chapter 4510 or any other provision of the Ohio Revised Code, or was operating a motor vehicle or motorcycle, did not have a valid driver's license, commercial driver's license, temporary instruction permit, probationary license, or non-resident operating privilege, and was not eligible for renewal of the offender's driver's license or commercial driver's license without examination under Section 4507.10. If you find that the state separately proved beyond a reasonable doubt all the essential elements of the lesser included offense of vehicular homicide under the If you find the state separately failed to prove beyond a reasonable doubt any one or more of the essential elements of the lesser included offense of vehicular homicide under the charge separately against Joshua J. Gaspar in count 2 of the indictment, your verdict must be not guilty according to your findings. If your verdict is guilty of the lesser included offense of vehicular homicide as charged in count 2, you must decide beyond reasonable doubt whether the defendant was guilty or not guilty of driving under a suspension or cancellation imposed, or was operating a motor vehicle or motorcycle, did not have a valid driver's license, commercial driver's license, temporary instruction permit, probationary license, or non-resident operating privilege and was not eligible for renewal of the offender's driver's license or commercial driver's license without examination. You will then indicate your finding on the verdict form, page 2. If your verdict is not guilty, you will not consider this issue. Again, motor vehicle has been previously defined, and the same definition applies herein. Count 5 is driving while under the influence. Defendant Joshua J. Gaspar is charged in count 5 of the indictment with driving while under the influence in violation of Revised Code Section 4511.19A1A. Before you can find the defendant guilty of driving while under the influence, you must find, beyond a reasonable doubt, that on or about the 15th day of September 2016 in Cuyahoga County, Ohio, the defendant did operate any vehicle within the state when at the time of the operation he was under the influence of alcohol, a drug of abuse, to wit methadone, or a combination of them. The term operate has been previously defined and the same definition applies here. Vehicle is defined under Revised Code 4511.01A as every device in, upon, or by which any person or property may be transported or drawn upon a highway. Vehicle includes a motor vehicle. Alcohol is defined as ethyl alcohol, whether rectified or diluted with water or not, whatever its origin may be, and includes synthetic ethyl alcohol, but does not include denatured alcohol or wood alcohol. Drug of abuse means any controlled substance. Dangerous drug is defined in Section 4729.01 of the Revised Code, or over-the-counter medication that, when taken in quantities exceeding the recommended dosage, can result in impairment of judgment or reflexes. You're instructed that methadone is a controlled substance under Schedule 2 of the Ohio Revised Code and is considered a drug of abuse. Under the influence means that the defendant consumed a drug of abuse, whether mild or potent, in such a quantity, whether small or great, that it adversely affected and noticeably impaired the defendant's actions, reaction, or mental processes under the circumstances then existing, and deprived the defendant of that clearness of intellect and control of himself which he would otherwise have possessed. The question is not how much of a drug of abuse would affect an ordinary person. The question is, what effect did any drug of abuse consumed by the defendant have on him at the time and place involved? If the consumption of a drug of abuse so affected the nervous system, brain, or muscles of the defendant so as to impair, to a noticeable degree, his ability to operate the vehicle, then the defendant was under the influence. If you find that the state proved beyond a reasonable doubt each and every one of the essential elements of the offense of driving while under the influence as charged in count 5 of the indictment, your verdict must be guilty according to your findings. You will then indicate your finding on the verdict form. If you find that the state failed to prove beyond a reasonable doubt any one or more of the essential elements of the offense of driving while under the influence as charged in count 5 of the indictment, your verdict must be not guilty according to your findings. You will then indicate your finding on the verdict form. All right, this is count 6. As I said, it's awkwardly denominated as motor vehicle offenses. It's more commonly called driving under suspension. Defendant Joshua J. Gaspar is charged in count 6 of the indictment with motor vehicle offenses in violation of Revised Code 4510.11a. Before you can find the defendant guilty of motor vehicle offenses, you must find beyond a reasonable doubt that on or about the 15th day of September 2016 in Cuyahoga County, Ohio, the defendant did operate a motor vehicle upon the public roads and highways or upon any public or private property used by the public for purposes of vehicular travel or parking, while his driver's or commercial driver's license or permit or non-resident operating privilege was suspended under any provision of the Ohio Revised Code other than Chapter 4509, Financial Responsibility Laws, or under any applicable law in any other jurisdiction in which his license or permit was issued. The terms operate motor vehicle were previously defined, and the same definitions apply here. The term public roads means public roads, highways, streets, avenues, alleys, and bridges within a political subdivision. Public roads does not include berms, shoulders, rights-of-way, or traffic control devices. Highway means the entire width between the boundary lines of every way open to the use of the public as a thoroughfare for purposes of vehicular travel. Property means any property, real or personal, tangible or intangible, and any interest or license in such property. The term driver's license means a license issued to any person to operate a motor vehicle or motor-driven cycle other than a commercial motor vehicle and includes restricted license. Driver's permit means a temporary instruction permit issued to any person to operate a motor vehicle other than a commercial motor vehicle. If you find that the state proved beyond a reasonable doubt each and every one of the essential elements of the offense of motor vehicle offenses as charged in count 6 of the indictment, your verdict must be guilty according to your findings. You'll then indicate your finding on the verdict form. If you find that the state failed to prove beyond a reasonable doubt any one or more of the essential elements of the offense of motor vehicle offenses as charged in count 6 of the indictment, your verdict must be not guilty according to your findings. You'll then indicate your finding on the verdict form. This is count 7. Defendant Joshua J. Gaspar is charged in count 7 of the indictment with tampering with records in violation of Revised Code Section 2913.42A2. Before you can find the defendant guilty of tampering with records, you must find, beyond a reasonable doubt, that on or about the 10th day of February 2016, in Cuyahoga County, Ohio, the defendant did, knowing he had no privilege to do so, and with purpose to defraud, or knowing that he was facilitating a fraud on a representative of the State of Ohio Bureau of Motor Vehicles, did utter a writing or record to it a tampered with application for a temporary Ohio driver's license, knowing it to have been tampered with as provided in Division A1 of this section, and the writing, data, computer software, or record was kept by or belonged to a local, state, or federal governmental entity. The term motor vehicle and driver's license were previously defined, and the same definitions apply here. Person acts knowingly regardless of purpose when the person is aware that the person's conduct will probably cause a certain result or be of a certain nature. A person has knowledge of circumstances when the person is aware that such circumstances probably exist. Because you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that he had no privilege to do so, and with the purpose to defraud or knowing he was facilitating a fraud. Privilege means an immunity, license, or right conferred by law or bestowed by express or implied grant, or arising out of status, position, office, or relationship, or growing out of necessity. Purpose is an essential element of the crime of tampering with records. A person acts purposely when it is his specific intention to cause a certain result. It must be established in this case that at the time in question there was present in the mind of the defendant a specific intention to defraud or knowing he was facilitating a fraud on a representative of the State of Ohio B&V. When the central idea, essence, or gist of the offense is a prohibition against or forbidding of conduct of a certain nature, a person acts purposely if his specific intention was to engage in conduct of that nature, regardless of what he may have intended to accomplish by his conduct. Purpose is a decision of the mind to do an act with a conscious objective of producing a specific result or engaging in specific conduct. To do an act purposely is to do it intentionally and not accidentally. Purpose and intent mean the same thing. The purpose with which a person doesn't act is known only to himself unless he expresses it to others or indicates it by his conduct. The purpose with which a person doesn't act or brings about a result is determined from the manner in which it's done, the means used, and all the other facts and circumstances in evidence. To defraud means to knowingly obtain by deception some benefit for oneself or another, or to knowingly cause by deception some detriment to another. Facilitating means helping, promoting, assisting, or aiding. To utter means to issue, publish, transfer, use, put, or send into circulation, deliver, or display. Writing means any document, letter, memorandum, note, paper, plate, film, or other thing having in or upon it any written, typewritten, or printed matter. It also means any token, stamp, seal, credit card, badge, trademark, label, or other symbol of value, right, privilege, license, or identification. Data means a representation of information, knowledge, facts, concepts, or instructions that are being or have been prepared in a formalized manner and that are intended for use in computer system, or computer network. Computer software means computer programs, procedures, and other documentation associated with the operation of a computer system. If you find that the state proved beyond a reasonable doubt each and every one of the essential elements of the offense of tampering with records as charged in count 7 of the indictment, your verdict must be guilty according to your findings. You will then indicate your findings on the verdict form. If you find that the state failed to prove beyond a reasonable doubt any one or more of the essential elements of the offense of tampering with records as charged in count 7 of the indictment, your verdict must be not guilty according to your findings. You will then indicate your finding on the verdict form. For count 8, defendant Joshua J. Gaspar is charged in count 8 of the indictment with tampering with records in violation of Revised Code Section 2913.42A1. Before you can find the defendant guilty of tampering with records, you must find, beyond a reasonable doubt, that on or about the 10th day of February 2016 in Cuyahoga County, Ohio, the defendant did, knowing he had no privilege to do so, and with purpose to defraud or knowing that he was facilitating a fraud on a representative of the State of Ohio Bureau of Motor Vehicles, falsify, destroy, remove, conceal, alter, deface, or mutilate any writing, computer software, data, or record to it, tampered with an application for a temporary Ohio driver's license. The terms knowingly, privilege, purpose, defraud, facilitating, motor vehicle, writing, computer software, data, and driver's license have been previously defined, and the same definitions apply here. Conceal means to hide, secrete, or keep from the discovery by or observation of others. If you find that the state proved beyond a reasonable doubt each and every one of the essential elements of the offense of tampering with records as charged in count 8 of the indictment, your verdict must be guilty according to your findings. You will then indicate your finding on the verdict form. If you find that the state failed to prove beyond a reasonable doubt any one or more of the essential elements of the offense of tampering with records as charged in count 8 of the indictment, your verdict must be not guilty according to your findings. You will then indicate your finding on the verdict form. This is count 9. The defendant Joshua J. Gaspar is charged in count 9 of the indictment with certain acts prohibited in violation of Revised Code Section 4507.30E. Before you can find the defendant guilty of certain acts prohibited, you must find, beyond a reasonable doubt, that on or about the 10th day of February 2016 in Cuyahoga County, Ohio, the defendant did, in any application for an identification card, driver's or commercial driver's license, temporary instruction permit, or commercial driver's license, temporary instruction permit, or any renewal or duplicate thereof, knowingly conceal a material fact, or present any physician statement required under Section 4507.08 or 4507.081 of the Revised Code, when knowing the same to be false or fictitious. The terms knowingly, conceal, driver's license, and driver's permit were previously defined, and the same definitions apply here. statement includes, but is not limited to, any notice, letter, or memorandum, proof of loss, bill of lading, receipt for payment, invoice, account or other financial statement, estimate of property damage, bill for services, diagnosis or prognosis, prescription, hospital, medical or dental chart or other record, x-ray, photograph, videotape or movie film, test result, other evidence of loss, injury or expense, computer-generated document, and data in any form. False means wholly or partially untrue or deceptive. If you find the state proved beyond a reasonable doubt each and every one of the essential elements of the offense of certain acts prohibited as charged in count 9 of the indictment, your verdict must be guilty according to your findings. You will then indicate your finding on the verdict form. If you find that the state failed to prove beyond a reasonable doubt any one or more of the essential elements of the offense of certain acts prohibited as charged in count 9 of the indictment, your verdict must be not guilty according to your findings. You'll then indicate your finding on the verdict form. This is count 10. Defendant Joshua J. Gaspar is charged in count 10 of the indictment with falsification in violation of Revised Code Section 2921.13a3. Before you can find the defendant guilty of falsification, you must find, beyond a reasonable doubt, that on or about the 10th day of February 2016 in Cuyahoga County, Ohio, the defendant did knowingly make a false statement or knowingly swear or affirm the truth of a false statement previously made when the statement was made with purpose to mislead a public official in performing the public official's official function. The terms knowingly, false, statement, and purpose were previously defined, and the same definitions apply here. The terms swear and affirm have the same meaning, which is to declare solemnly that statements made or to be made are true. Public official means any elected or appointed officer or employee or agent of the state or any political subdivision, whether in a temporary or permanent capacity, including without limitation, legislators, judges, and law enforcement officers. If you find the state proved beyond reasonable doubt each and every one of the essential elements of the offense of falsification as charged in count 10 of the indictment, your verdict must be guilty according to your findings. You will then indicate your finding on the verdict form. If you find that the state failed to prove beyond a reasonable doubt any one or more of the essential elements of the offense of falsification as charged in count 10 of the indictment, your verdict must be not guilty according to your findings. You will then indicate your findings on the verdict form. Ladies and gentlemen, the date of the offenses in this indictment when they allegedly occurred has been previously stated, but it's not necessary that the state prove that the offenses were committed on the exact day as charged in the indictment. It's sufficient to prove that the offenses took place on a date reasonably near the date claimed. Because this is a criminal case, the law requires that all 12 of you be in agreement before you can consider that you reached a verdict. I have the verdict forms here. I'm not going to talk with you about all of them, but I will talk with you about a couple so that you understand the operation. I'll go slow. For instance, for count 1, it has up here the count number and it tells you what type of offense it is. And it reads, for instance, we, the jury in this case, being duly impaneled and sworn, do find the defendant Joshua J. Gaspar, and then there's a blank. In the blank, according to your findings, you're either going to insert in ink either guilty or not guilty, whatever you as a body decide. So either guilty or not guilty of aggravated vehicular homicide in violation of Revised Code 2903.06A1A as charged in count 1. Now there is a space for 12 to sign. So if all 12 of you are in agreement, or when you are, you'll all sign. Now, it doesn't have to be in the order of your seats or anything, all right? Usually I think that people sign according to how they're seated around the table. You probably have all had your chosen seats there for days, right? So that's usually how they're signed. All I'd ask, if you're a person that's very creative and artsy and you have a signature that no one can read, halfway to being a doctor, sign it a little bit more legibly so that I can be assured that it's your signature. But again, there's no magic to where you sign. It's just the fact that all 12 have to agree on the verdict and have to sign in ink, and then you put your verdict decision up here. Okay? Now, for this particular offense, there's an instruction at the bottom. If you find the defendant guilty in this form, you'll then consider and complete the following further finding and specification. So if your verdict is guilty, then you move on to the further finding about the driving under suspension. I won't read it to you, but we've read it several times. And in the blank, you'll further find and specify that the state proved beyond a reasonable doubt the defendant is guilty or not guilty of driving under suspension, and all that's alleged there, okay? So when you reach a decision, either put guilty or not guilty on this further finding, all 12 will sign. Also, if your verdict was guilty, you'll move to the second peace officer specification. It says, the jury in this case, having found the defendant guilty of aggravated vehicular homicide, further find and specify that the state proved beyond a reasonable doubt that the victim of the offense is or is not a peace officer. So that will be your decision there in the blank, in ink, and all 12 must sign, indicating your agreement to that verdict. So that's how count 1 works, for instance. You are given instructions for how to proceed on count 2. So your decisions on count 2 will be in accordance with the jury charge. So you maybe filling out one form, maybe filling out another form. That will depend upon your decision making in count 2. Okay. But there are also further finding or a specification that may apply. I just point out though that for count 2, the lesser included of vehicular homicide, there's the further finding, but there is not a form for the specification for a peace officer. Okay, so these 2 pages are all you would get for the lesser if you reach this stage. And all the other verdict forms have just a single page. You'll either put in there, depending upon your finding, guilty or not guilty, and all 12 must sign. Ladies and gentlemen, at this stage of the trial, you may not discuss or even consider the subject of punishment. It's your duty to carefully weigh the evidence, decide all disputed questions of fact, apply the instructions of the court to your findings, and render your verdict accordingly. Your efforts must be to arrive at a just verdict. I ask that you consider all the evidence and make your findings with intelligence and impartiality, and without bias, sympathy, or prejudice for or against either party, so that both the state of Ohio and the defendant, Joshua J. Gaspar, will feel that their case was fairly and impartially tried. Now, upon your retirement to the jury room, you'll immediately proceed to select one of your number, man or woman, as foreperson. That person will preside over your deliberations. The foreperson has no greater authority or power than any other member of the jury, except that the court charges the foreperson with the responsibility of ensuring that each juror is given an opportunity to express his or her opinion on the evidence. When you've reached a verdict, you'll sign the verdict form in ink, which agrees with your findings. Usually Mary Pat will provide the foreperson with an envelope, so whenever you have your verdict forms completed, you put it in the envelope, you can seal it, and the foreperson puts their name on the front. That way, we are confident then that nobody has access to your verdict until I read it here in court. Okay? If you have a question about these instructions, it should be discussed first in the privacy of the jury room. If you disagree as to the meaning of these instructions, it may be possible, under certain conditions, to review those matters by request of the court. If you desire to address any communication to the court, you must reduce it to writing and have it signed by the foreperson. The question usually will be answered in open court, but if I only answer it in writing, I ask that you save the question and the answer with the evidence. So you're going to go back, you get back there, Mrs. Smith will bring you the verdict forms and the jury charge that I've just read to you. You'll get the evidence, and all that comes back in here at the end, along with any questions or other things that were in there with you. Okay? When you've reached a verdict, you contact this room through the bailiff, and your verdict will be read in open court. I'll just caution you, the buzzer that's used is really loud and annoying. So if just a short burst will get her attention, I guarantee. I have one in my office. I never use it because it would be very detrimental to our relationship if I did. Okay. When I say that we'll read in open court, what we do, we'll have our alternate separately sequestered, and then when you have a verdict, we bring all of you back in. I question the alternate to make sure that she hasn't discussed the case with anyone, and you'll be asked the same thing. And then the foreperson gives the envelope to the court. I read through it to make sure they're complete and consistent, and I read the verdicts. And then I turn to each of you, and I go by your juror number because I would never get your names right at that point because I'll be tired. So I just say, juror number 1, is this your verdict? Number 2, is this your verdict? And I go through all 12 just so that the parties are confident that the verdict that's been rendered in writing was in fact your verdict, and that nobody has been coerced or bullied or anything else into reaching a verdict. Okay? After the verdict is returned and you're discharged as juror, you may discuss the case with anyone or not, as you choose. Some of our jurors stay and talk with us. Some people don't want to talk after they've been through a juror experience. That's up to you. We're always happy to talk with jurors, but it's your right. So if you don't want to talk with anyone, you don't have to. If you want to stay and talk with us, you may. I just say that until a verdict has been returned in open court, you may not discuss this case with anyone or let anyone discuss it with you. So you're going to go back. The 12 who are deliberating will close the door. Usually you would select a foreperson at this point, and you may opt for lunch or something. When all 12 are together, you can discuss the case, but when the door opens, you have to stop. So it requires all 12, and it requires that door to be closed before you can discuss this case. And then once you're outside of the court, you can't discuss it at all with anybody until a verdict has been returned. Okay? So counsel, you may now approach the bench, and you can place any objections to the charge on the record. In a moment, we're going to excuse our alternate from the jury of 12 for deliberation, but will remain separately sequestered in this case until the jury reaches a verdict, since your continued service as a juror on this case may be required until that time. You're instructed not to tell anyone what your verdict would have been, or to discuss anything about the case until you hear that a verdict has been read in open court. Ask that you remain seated, and when the others go out, you'll be with them because you are an integral part of what we've been doing. And if you have a notepad, you can just give it to Mrs. Smith and she'll keep it. Counsel, you're directed to check the exhibits so that only admitted exhibits will be sent to the deliberation room. Ladies and gentlemen, the law in constituting a jury of 12 jurors contemplates that each of you shall give your individual consideration to and judgment upon the evidence. The The rules of law which are explained to you in these instructions are binding upon the individual conscience and judgment of members of the jury. While deliberating, each juror should give careful consideration to the views which a fellow juror may have to present. A juror should not turn a deaf ear to those associate jurors and, without listening to their reasons or arguments, obstinately stand upon his or her own opinion regardless of what may be said by another juror or jurors. It must be the object of all of you to arrive at a common conclusion. And to that end, you should deliberate together with calmness and in a dispassionate manner, being considerate of each other's views. You should have in mind two propositions of equal importance. First, that the laws are enacted for the benefit of all members of organized society. And when a jury is convinced beyond reasonable doubt of a defendant's guilt, the jury should so say in its verdict. And secondly, that no defendant should be convicted of a crime when the jury is not convinced of such defendant's guilt by evidence beyond a reasonable doubt. I ask that you let your verdict be fair and impartial, thus assuring that you've been mindful of your oath to well and truly try and true deliverance make between the state of Ohio and the defendant in this case, Joshua Gaspar. Ladies and gentlemen, the case is now in your hands for a verdict. Thank you.
All rise. You can bring your notebook with you. Please step in and put your